Yo. Oh no. Yo. What's good, family? So at 2 o'clock, we got 5 minutes. 5 minutes. 5 minutes to get fresh. Yeah. On. 5 minutes. I don't know if they're gonna start on time. So we are gathering. We are gathered here today, ladies and gentlemen. I'm gonna act up because I listen. I ain't got nowhere to be today. I don't have to be a lawyer today. Okay, I'm gonna play one on YouTube today. Yep, that's what's gonna happen. That's what I'm gonna do. I'm gonna play one on YouTube today. We got 5 minutes that this hearing is supposed to be started. So if you've been under a rock and you're not quite sure what's going on, we have the continuation of the Fonnie Willis and Nathan Wade disqualification hearing. Remember, we stopped that hearing so the judge could do an in-camera review or inspection, basically, of Terence Bradley's mind. Basically, the judge was like, bruh, what you just said does not give me any confidence that you actually understand the client, attorney-client privilege. So, hold on, let me see my comments. This is the case. So, hey, family. So, yeah. I can see comments. Look, I'm not struggle streaming today. So the judge decided after 90 minutes of an in-camera examination, the judge determined that Terence Bradley, should get back on the stand and that what he claimed was privileged information is not and should be subject to questioning. Yep. So 2 o'clock, he's going to get back on the stand. I'm checking to see who's live and who's not, because I don't know whose stream we going to jump on. But I'm watching to see who goes live first. It's a couple of Atlanta outlets that are claiming they streaming, but I'm not streaming their news. I'm only streaming, The Hill. You know what? The Hill. I trust The Hill. I'm going to go. Don't want to. Hold on 1 second, family. I don't want to. Oh, shit. Hold on now. Let me find out. I don't want to be late, goddamn, either. All right, hang on. I'm going to tell y'all, I think somebody tried to scam me today. Yeah. I'm going to tell y'all about that later. Hold on. I always doing something wrong. So it hasn't started yet. We have not gotten underway. Is family behavior on the stand professional? She was absolutely unprofessional, Code Red. Absolutely unprofessional. That is not what you want to see when you are before the court who has to determine whether or not you should be disqualified. And I get that you angry. I get that you have your righteous indignation. I get that you feel attacked. I get all of that. But never let them see you sweat. You should have came in there composed. You should have came in there prepared. And you should have answered those questions directly. You did none of those things. You did none of those things.
So I got to move that mic some without speaking. It's on.
Yeah, thank you. You know he gonna. You already know what's gonna happen, right? Y'all know he gonna have amnesia, early onset dementia, or he gonna fake a heart attack, some shit like that. Unknown caller. I don't know. It says none. What does none mean? I'm not answering that. Peace to the Earths. True Fist of the North Star. Peace to the gods and the Earths. Because, brother, there is no you without me, right? All right. Peace to the 5% nation of gods and earths. Today's math is wisdom, God, all being born and born. Yes. Wisdom, God, all being born and born. Yeah, I still know my lessons. Some things you never forget. When you knowledge 120, you should never forget that foundation. Yeah, I don't know how many lawyers you know that know 120. I'll be different out here. You heard? I'm paralegal in the next office cracking up. Yeah, Fanny's going to be replaced. Y'all want my prediction? I predicted this already. I told y'all she's got to be disqualified. Only to maintain the integrity of the proceeding. He's not going to dismiss the case, right? And so to preserve the integrity of what's left of that case, got to get rid of her and Nathan. They got to go. Facts. That's facts. Only you, Queen. Facts. Only you, Queen. Knowledge God. 1717. 17. They say they're Queen, but they don't know 17. Somebody put a 17 in the chat. Mikey Fairman, what's up, Mikey? Let me put the link in the chat just in case anybody want to join me. Y'all know how I feel. I'm getting better, y'all. I'm getting better. I am. I'm getting better. Oh, shoot. I got to call Dennis back.
All right.
See me stand up. I can't even help myself.
Thank you all. Please be seated. All right, we are back on the record with 23 SC 188947. If we could have counsel starting with the state identify themselves for the record for the purpose of today.
Adam Abadi for the state, Your Honor.
All right, and in order of the styling, let's start with former President Trump. I think we have Mr. Sadow on Zoom.
You do, Your Honor. Good afternoon. Steve Sadow for President Trump. We waive his presence, and I believe Ms. Little is also on Zoom. And
all right. Okay, thank you, Mr. Sadow. On behalf of Mr. Giuliani.
Alan Stockton on behalf of Mayor Giuliani. I think David Lewis and John Esposito may be on Zoom as well. And we waive his presence.
There we go. On behalf of Mr. Meadows.
Your Honor, Jim Durham on behalf of Mr. Meadows, and he waives his appearance.
Thank you, Mr. Durham. On behalf of Mr. Clark.
Attorney McDougald, Your Honor, and he also waives his appearance.
Thank you, Mr. McDougald. On behalf of Mr. Cheeley.
Good afternoon, Your Honor. Richard Rice, President Court. Chris Anulowicz is on Zoom, and Mr. Cheeley waives his presence.
Thank you. On behalf of Mr. Roman.
Good afternoon, Judge Ashley and John Merchant, on behalf of Mr. Roman, and he waives his presence.
All right. On behalf of Mr. Schaefer.
Greg Gillen and Anthony Lake on behalf of Mr. Schaefer, and he waives his presence.
On behalf of Mr. Floyd.
Come on, Mikey.
Morning, Your Honor. Good afternoon, Your Honor. Chris Kachuroff and Mr. Floyd. We also waive Mr. Floyd's appearance.
Thank you, Mr. Kachuroff. And on behalf of Ms. Latham.
It worked for a little while.
Anybody here on behalf of Ms. Latham? All right. I know before we'd had Mr. Cromwell And I had not heard anything from him. I don't know if any other parties have as well, but
Your Honor, I believe Mr. Cromwell is in a deposition in South Georgia. That's all I know.
all right.
There's a Zoom participant, Mr. Cromwell.
Looks like he joined.
Okay, that's helpful to know. Mr. Cromwell, can you hear us? All right. Well, we'll keep an eye on that to see if he does join us, and we'll take it up as it comes. So, just a few preliminaries. First of all, I'm a bit under the weather, so I'll try to speak up, but if anyone can't hear me, just let me know. I'll try to talk close to the microphone. But we are here today, the sole purpose of which is that at the conclusion of the hearing on February 16th, I announced that I'd be meeting with Mr. Bradley in camera to assess the validity of his assertion of attorney-client privilege. I've now been able to do that, and I also allowed Mr. Wade the opportunity to weigh in and respond as well. And after considering the testimony, not only in camera, but also of what came out at the hearing, I found that neither Mr. Wade nor Mr. Bradley had met their burden of establishing that the attorney-client privilege applied, specifically as it relates to Mr. Bradley's knowledge of any relationship that existed between Ms. Willis and Mr. Wade, and particularly that it wasn't established that his specific knowledge came about in furtherance of legal advice. So having made that determination, I didn't see any other choice but to allow the parties to have an opportunity to explore that topic with him. There's really, in my mind, it's that topic only. I think that if there's anything else we've already covered, I'm not here to do it again. So with that, is there anything else we need to cover before kicking that off?
See you, Mikey.
Just, Mr. Wade, he's still a potential witness, I would assume. And so he needs to still be excused. We can go continuing.
Mr. Abadi?
I believe Mr. Wade was released from his subpoena when we concluded his testimony at the last hearing. So unless he's been resubpoenaed, and I have no knowledge of that, he has every right to be present.
Sure. I think procedurally that would be accurate. And so
He should be
at this
subject
point,
to
I don't see
recall.
a means where he would need to be recalled.
Okay.
And but if it is, then that is something you can take up.
He should be
All right.
sequestered.
Mr. Bradley, through his attorney, had informed me that he would be here today in person. I don't see him in the gallery. Do we know if he's out in the hallway?
He had the doctor's
Okay.
orders again?
All right. If we could call for Mr. Bradley.
Here we go.
Judge, would it be permissible to sit in the jury box?
That's fine. All right, Mr. Bradley, Deputy Scott will swear you in again.
Get to the court for the truth, nothing but the truth to help you.
I do.
Please be seated. First and last name for the court.
Terence Bradley, Terrence, Bradley, Bradley.
Ms. Merchant.
Thank you, Judge. Good afternoon, Mr. Bradley.
Good afternoon.
Good to see you. Sorry, under these circumstances. I'm going to just go straight to where we left off before. Bonnie Willis and Nathan Wade were in a romantic relationship, correct?
Correct.
And it began at the time that they were both municipal court judges, correct?
Objection, Your Honor, based on privilege.
Overruled.
Motherfucker, you cannot
Okay,
use that.
overruled.
You really gonna go with privilege?
I do not have knowledge of it starting or when it started.
That wasn't the question.
Terrence, you told me that it started when they were both municipal court judges, though, correct?
That is incorrect.
Get his.
You never confirmed in writing that it was, instead of magistrate court, it was in municipal court when they started dating?
If you're speaking of the text message, you can go to that text message and you can read that text message, and I will explain the text message to you. But you and I did not have a conversation about when it started. You asked a compound question of magistrate court versus, I mean, you said it was magistrate court, municipal, you said magistrate court conference, I'm sorry. And then you asked another question. I said no, municipal court, nothing else.
I'm referring to a different conversation. I asked you, do you think it started before she hired him?
Your Honor, I'm going to object. This was covered in the previous hearing where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of and actually used in an attempt to refresh his recollection. And he explained exactly what he's explaining here before the court. So this is repetitive
rules of
and
evidence.
unnecessary. And so I would
Past
object
recollection
to
recorded.
past and answered
Admit
and
the
relevance to
fucking
this point.
text message.
All right, perhaps we'll get there, but I think first, Ms. Merchant has the right to draw his attention to the exact, potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled. You may.
If my students are in here,
You can see it.
if my evidence students are in here,
I gave you at the last hearing.
this is impeachment.
And for purposes of the record, I believe, Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
This one was not tendered,
All right.
and I'm happy to tender it.
Well, just
Yes, you are.
take it as it
happy to
comes,
tender it.
whatever you.
We're at, I think we're at 39. I will wait to mark it, but I think we're at 39. May I approach, Judge?
You may.
All right. So Terrence, do you remember telling me that it started when she left the DA's office and was a judge in South Fulton?
I see the message there, but I don't recall. I do see that message, but I do not recall.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. No, ma'am.
And when I asked you if you thought it started before she hired him, and you responded absolutely.
Your Honor, I'm going to object as to the source of the information that Mr.
Overruled.
Bradley allegedly gathered this from.
Overruled.
There's been absolutely no foundation, and based on the arguments at the last hearing,
Shut the fuck
that a
up.
lot of this is based on gossip, innuendo, assumption,
answer that.
and privileged information.
Judges
And
don't
at this
get
point,
money.
Ms. Merchant has not provided a foundation as to how
Can't you
Mr.
say
Bradley would have
overruled,
any
Judge?
information
Say
that she
overruled.
keeps referring to.
All right. I think
Judge,
that's, go ahead, Ms. Merchant.
I didn't ask him about the source of the information. And under Rule 621, I can impeach him with any inconsistent facts.
That's right.
This is an inconsistent fact. I can impeach him with any contrary facts.
Sure.
This is a
Why would
contrary
it be
fact.
a relevant impeachment if he actually has no personal knowledge of this?
If he doesn't.
Sure.
have
So
personal
I think you have to lay that foundation then, so that'll be sustained.
knowledge.
That was terrible.
Do you remember telling me that it began?
Well, that doesn't address the issue.
No, I'm not. I was just asking if you remember telling me as opposed to the
Okay,
text.
sure.
Do you remember telling me that it began?
Well, no, and then you're going into the substance of it, which we haven't
So you
determined
remember
whether he
us
actually
having a
knows or
text
how he knows.
conversation.
You told me,
Oh, God.
in fact, you corrected me when I said magistrate court. You corrected me and said it was municipal court. Do you
Yeah.
remember that?
Same objection, Your Honor.
This is the exact same issue, right?
Well, I'm
Yeah,
asking if he remembers that. He hasn't answered that question yet.
He said he
right,
doesn't
but the relevance of whether he remembers it isn't established until we know how he remembers it or why he knows it. If that makes
That
sense.
doesn't make sense.
I guess
Judge.
not.
No, it
Sorry.
doesn't.
How he knows it? I'm just asking
No.
if he told me that.
Right.
So I wasn't
Establish
asking
it.
how he
said
knew
it
that.
first.
I wasn't asking the source of that knowledge. I was asking if he told me that. That
Sure.
was it.
But that's the point. It's how he knows it.
Right.
The source of his knowledge, the state would contend is hearsay because it's gossip and innuendo, which is what was indicated the last hearing.
Well, it may not be hearsay. It may not be gossip. We haven't really gotten there yet. We don't know how he knows what apparently he's telling her. And I think we need to figure that out before we can go any further.
Yes. And if the source of the information is a witness who've testified, then it's not hearsay. So when did the relationship start?
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times today. He said he has no idea the timeline
They
or
are
when
trying.
it occurred.
Did you see
Those were
how
the first
desperate
questions
these
that Ms. Merchant
motherfuckers
asked.
are?
I didn't ask when. I asked his first knowledge. He testified he has knowledge that they had a relationship. I asked him when he first got knowledge of that.
Okay. So if the question is, when did you first get knowledge? I think
That's appropriate.
We can start there.
That was the question. Yes.
All right.
Thank you. When did you first get knowledge of their relationship?
I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started.
And that wasn't my question. So my question is, when did you first gain knowledge? I didn't ask the source of the knowledge, didn't ask you to comment on the validity of the knowledge. I asked when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection, overrule it. He can answer that.
And just for the record, and I appreciate your honor, but he said he had no personal knowledge, so it's, he had to gain the knowledge not from hearsay.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of us learn things from hearsay. The question of whether it's admissible, right? And that's what we got to get to. So
I apologize.
When did you first get knowledge?
You should
I'm
say,
not
when did
qualifying
you
what
first
type of knowledge. I'm
learn
just
to
asking
get
when you first
knowledge
knew about
is-
the relationship.
Her questions are bad. When's the first time you saw them kiss?
I don't know how to answer that.
You ever
I
seen them
mean,
kissing before?
so I can't give you a date if you're asking for a date. If you're asking me, how did I get the knowledge?
That's privileged.
It would have come directly from a client.
That's
So
privileged.
help me understand.
No, that's not
you say you
privileged.
can't answer that question. You don't know the date. So that's the answer to the
Oh my-
question.
But I said that 5 minutes ago.
We have to make it clear.
Yes,
All
sir.
right. Next question, Ms. Merchant.
So you don't know the specific date.
No.
Do you know if can we narrow down the timeline? Did you gain knowledge in 2019 of this relationship beginning?
I'm gonna object to this
No,
line of
she
questioning,
doesn't
as he said
know
he
how to
does
ask
not know
Sure.
when he gained.
All
No
right.
one
He doesn't know the specific
That's
date.
fine, Ms. Merchant. I think I'm overruling that. I think we can try to see if he can narrow it down based on
The years?
goalposts.
Thank you.
19, I would probably say no. I mean,
Probably.
I don't have anything that there wasn't a specific date. There wasn't a football game. There wasn't something that I can attribute to him telling me whatever. And so you're asking for a date, you're asking for a year, it's still a date. And at this time, I am telling you that I do not have the date.
He's a fucking liar.
Let's try this then. So you received a contract from Ms. Willis, January 2021, correct?
Can I see the,
Yes,
I think so.
Exhibits are, I think, okay.
I think if it was from the exhibits, I think it was 21, yes.
And I don't want to belabor the point, but you did those
Yes.
when you were here before.
Yes.
If those documents that you looked at last time,
Yes,
said January 2022, that's, okay.
21. I
I'm
didn't,
sorry, 21, you're right, thank
and
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was, that we have in the record is January 25th, 2022. So using that date,
There
at
we
that
go.
point, had they begun their romantic relationship?
Of 2022,
January 25th, 2022, 2021, I'm sorry. When you got your first contract?
I,
Should be easy.
I don't recall,
There you go.
He's
Just
not
say that.
I don't recall
say
any,
that
any
faster next time.
specific dates.
Just say it faster.
No, ma'am.
You're gonna say it. Just say it
Do you
faster.
remember when you got that contract though, correct?
I remember I had the contract, yes.
Okay. And you told us last week, or I guess it was the week before now, you told us that Mr. Wade brought you that contract, essentially told you about that contract.
That is correct.
So Ms. Willis is not the one that brought that contract to you directly. It was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship though,
I'm
correct?
gonna object, Your
I
Honor.
can't say that.
Characterization of what Mr. Bradley just said. He just said he does not remember. There's nothing specific.
He doesn't remember the exact date. And I think the question now is to reference it or tie it to maybe some other event that he might
So
remember.
sit
I agree
down.
with Your Honor. She asked that specific question.
You
He
look
said
crazy
he does not remember any
objecting like
specific
that.
dates after signing the contract. That's exactly
Sure.
what he just said. This is
All
asked and answered.
I know, and we're getting to the end of it. So,
No,
Ms.
we're
Merchant,
not,
you don't have
Judge.
much
Oh my
more
God.
to pull on here, but
Question
he answered that
mark
last
is
question. So
not-
what's your next one?
I hope somebody else got some good
And
questions.
Judge,
That
I
was
didn't
there.
hear the answer if they were in a relationship
I
January
ain't heard one
25th,
good
2021.
question.
Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked me about him bringing me a contract. I said he did bring me a contract, and that is accurate.
Do you remember knowing Miss Willis prior to her taking office as the DA?
I had very little contact with Miss Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes.
Hey,
Knew
Ike.
her through the business. So
When
you had
did you
met
meet
her prior
Miss
to your
Willis?
contract.
I'm going to object to
Let's
relevance
read
at this
your
point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now. And so I'm trying to create a timeline to hopefully piece this together.
All right.
Stop
Well,
leading and start. Just a thought.
I'm not seeing really the likelihood that that's going to have any success. I'll let you ask a few more questions, but if he doesn't have a date, then I don't know that you're going to be able to create one today.
Okay, thank you.
She's scrambling.
Shut the ta.
So the time that you had this contract from January 2021 until January 2022, did you come in and out of the DA's office?
Yes.
Okay, and so were you able to witness Mr. Wade and Miss Willis interact during that time?
I'm going to object. This has been asked and answered. It was
No,
addressed
that has not
at the
been
last
asked and
hearing
answered.
about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that
Sure.
he rarely saw them together, but this was
Yeah,
answered.
I think the only avenue that was closed at the last hearing was his personal knowledge,
Right. So
potentially
sit down.
through, well, actually, no, if he testified, it was that he had no personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you correct me if I'm wrong,
Knowledge that was conveyed to him by,
by somebody else. That's that he claimed at the time was privilege. I found that it's not.
It's not.
That's what we're here to explore.
Explore that then. Come on,
Um,
merchant. Stay within the confines of what the judge is allowing you to ask.
do you remember telling me that not many people knew where they met?
I'm going to object as to relevance as to his personal knowledge, which is what 602 requires.
Yeah, I mean, we're back to the same point,
602?
Ms. Merchant.
His personal knowledge is what I'm asking
Students
him
out
what he
there,
told me.
602.
But he hasn't yet
Personal
told you
knowledge.
how he knows that. And so if, unless you can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would be
Then
the
ask
next
him.
That would be the next question.
Then
But I
ask him
first,
how he knows it.
I first have to establish that he said that.
No, you don't. You could go the other way
I
around.
need Steve sat out.
When you told me that it started when she left the DA's office and was a judge in South Fulton, where did you gain that knowledge from?
Ike, she gonna put her head through this brick wall, no matter how many times it takes.
Well, I'm going to object because his testimony a few minutes ago is that he did not recall making that statement.
All right, I'll overrule that. Mr. Bradley, answer the question if you can.
Get you next time, brick wall.
Repeat the question.
When you told me that their relationship started when she left the DA's office and was a judge in South Fulton, where did you obtain that knowledge from?
I was speculating. I didn't
That's
have
not the answer, bro.
a,
You have a basis of knowledge? You have a basis of information?
Do you know where you are right now?
no one told me I was speculating.
Based on
No one
what? Based on
told
your
you that?
observations?
No one told me that.
You were speculating based on things that had been told to you or things you had observed?
So I'm going to object as to
No.
the nature of
We need to know why he
this
was
line of questioning, because the witness has made it clear he was speculating as to how or what he knew.
Based on what?
And if it's speculation,
Caused
it's
him to
inadmissible
speculate.
for this court.
All right, but the motivations for his reason for speculating would be admissible,
Yes,
so I'll
yes.
overrule that.
Thank you, Judge. Was this speculation
Just-
when you
what's
told
the
me
basis
that?
of
Was
the
that based
speculation,
on
Ashley?
Things that had been told to you and things that you had witnessed?
Compound.
I never witnessed anything. So, it was speculation. I can't tell you
My name's Muffin. I don't know nothing.
anything specific, if that's what you're
In it.
asking.
Ain't in it.
Tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean, I don't recall, but no, I don't.
Did you have any reason why?
I don't know if speculation is lying, but
Well, let me just show me where in this text it says you're speculating. Or
You didn't ask me
Objection.
if I was speculating or guessing.
Oh,
I didn't ask you, but tell me if it says anywhere here that
No,
this is
it-
speculation.
If this is the same one that you just showed me, it does not.
And you're welcome if you need to look at your text. Is there anywhere in here that indicates that you didn't have knowledge of
No.
the relationship?
Your Honor, I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. She's explored that. He said it's speculation and he didn't get it from any source other than his own speculation.
Sure.
So
I think we're flushing that out. And I think it's her right to
explore that and impeach him.
have a little leeway on this if he's an adverse witness.
This judge
Judge, and
definitely
Judge,
had an edible before.
These speaking objections are clearly coaching the witness because he's regurgitating.
Your Honor, I
What-
object and take offense to that
No,
comment.
we
I'm
don't
objecting
fuck the
based on the
feelings.
law and I'm making a record for the court.
All right.
So I take
unoffended shit.
offense
Fuck you
to that
and your
comment. It's
feelings.
not the case.
All right. Well, I think we can start with objection, the grounds, and the rule number. And then if I need more, I'll ask.
Thank you.
All right.
Thank you. What did Nathan tell you about the relationship?
Objection, hearsay.
Nathan has testified. It's not
Yeah.
hearsay.
It's still hearsay. It's an out-of-court statement being brought in for the truth of the matter
You're not offering
asserted.
it
So
for the
hearsay.
truth, Ashley.
Judge.
Say I'm not offering
Yeah,
it
this would be
the
for
truth.
impeachment by contradiction, which would
Thank
be an
you.
exception to the hearsay
Thank
rule,
you.
and admissible as substantive evidence, and the privilege issues are overruled.
Thank you, Judge.
See, students, this is why you need to know the rules of evidence. So you
Well, I
can
think you just overruled the
objection.
public objection, but we don't know
Fuck
when
you,
he's
the judge
talking
already
about,
ruled.
so we've already established the
Down.
December
Right.
2018 date of privilege.
Sure. And that's something I covered in the in-camera hearing, and I'm, based on what he told me in that in-camera hearing,
Good on that.
I don't believe any statements to this effect
Man,
covered by
court
privilege.
looks like
And
a
Judge, I just
pain
want
in
for the record, because
ass.
sometimes the record doesn't reflect where people are looking.
Battle,
And that
baby.
when I ask a question, Mr. Bradley is looking at Mr. Wade and his lawyer to wait for them to object. And they're clearly interacting somehow
Yep.
in the court.
Yep.
So I just want the record to reflect
Yep.
that because
I
it
hate
wouldn't
when that shit
otherwise.
happen.
It's there now.
Thank you.
Do you have a question
No
was
way to
put to you, Mr.
defend
Bradley?
against that. except to
Judge, one of my
stand
lawyers is
so that
standing,
you
is
can't
sitting
do that.
right in the back,
We
that's
don't have to go down
behind.
that route.
No,
You
no.
can look wherever you want.
Motherfucking bullshit.
Cold scouting was important to me because I did
Sounds true.
All right. Mr. Bradley, question was put to you.
Repeat the question, please.
Yes. So I showed you, or I asked you, I'm sorry, the last
Why,
question
I'll
I
be
asked
here
you
all
was,
day.
what did Nathan Wade tell you about the relationship?
4 questions. 8 hours.
Same
of work.
objection, Your Honor.
And that's already been ruled upon.
So sit down. This judge
Take
has
his
so
chair.
much patience.
He
I
had an
recall
edible
him
guarantee.
stating that at some point they were dating. I can't tell you what date that
Was
was.
it before his cancer?
It was made in
or after the
confidence.
cancer?
We were in the back of our office. Our offices were the only two in the back. There was no one else present. That is all I can tell you at
He's
this
trying to say
time.
it was privileged since no one else was there.
One time?
One time.
You only had a conversation with him one time about the relationship?
Objection, asked and answered.
Oh, sit
No, I think
down.
that's a clarify for a thorough and sifting cross. Ms. Merchant.
I do not recall any other time that he mentioned that they were in a
Was it
relationship.
before
No.
or after his cancer diagnosis?
You may not.
Like she has all the tools she needs to make a timeline. She just
She's
refuses to do it the easy way.
Because she's incompetent.
Making
So
the
other
hardest
than,
way
so you talked
possible.
about this one time, and you said you don't know when it was though, correct?
That is correct.
Was it before Mr. Wade, before you got the contract in Fulton County? Let's start with that.
I do not recall.
Okay. And how did it come up?
Gotcha.
Say again.
How did it come up?
I do not recall how
There
it
you
came
go.
up.
This whole takes
It
too
was in the back. I know where it occurred. In our offices in the back. I can't tell you what we were discussing prior to that.
Did you receive an email from me on January 6th with a motion attached?
I think I did. Yes. Yes. I know. I received I don't know if the date is January 6th, but yes, I received that.
Okay.
Yes.
That's
So
what
you
we'd be
remember
ducking
receiving
jury
that.
duty.
Yes.
It's the date. And you reviewed it, and then you and I spoke about it. Do you recall that?
Hell no, he don't recall.
It's gonna take him 10 seconds to say it though.
Painfully.
Do we speak over the phone or are you saying through a text?
That's what I'm asking you. If you
I
recall
can't
speaking-
remember whether it was text to phone or
But you recall us speaking
Don't
one
work
way
for
or another.
Trump.
one way or another.
She's
Yes.
Roman's lawyer. Trump can't fire her. Trump's lawyer's next. All the lawyers that came up in the beginning, they are going to have their turn.
Oh Lord,
Uh-oh. That's not me.
that's the internet.
They don't want us to be great.
Getting too close to the truth.
Right. It's the that's the P whatever W Pix 11. Let me see what's going on with their site. All right, hang on, people. Let me put Mikey back in here. Oh, you in there? All right, let me see if they're back.
Yeah, they're
No.
back.
I'm not on my side.
On the hill?
Yeah, I'm on the hill. No, am I on the hill?
Oh, now it froze again. Let
Yeah.
me see if someone else has it.
Yeah, the hill. They're frozen on me too. Still.
Yo, you know they out there in the ocean cutting internet lines. Don't think, don't think it's just your imagination.
It's not a game.
Your internet may be going out sometimes because they out there
Oh, shit.
chainsawing them things.
Yep, it's still
Atlanta
doing
News
it.
First is going.
It's still doing it.
You want that link?
What'd you say? Who?
Atlanta News First.
Atlanta News First. All right, hang on. Let me go.
I got
let me
you.
go find them. You got it.
Where our chat at? There we go.
Okay. Our chat is on the side. Oh, you on the private chat or okay?
Yeah, I threw it in your private chat.
I got it. Hold on.
Yo,
Let me
why
get
do they
past
even
you.
have comment sections for these things?
I'm
This shit
telling you,
is
it's so
comedy.
annoying. And nobody wants to see their fucking.
Oh my! I just wait for
Your
the waves
motion.
of bots to show
I didn't
up.
reach out to you to say that that I'm going to be in your motion
Right.
Yeah.
I asked you to review it for accuracy.
for accuracy, and I just stated that it was inaccurate.
And the
They said
inaccuracy
she
that
looked
you
dried
pointed out
up.
was the
Come
thing
on,
about
man.
your-
These people
or how
are
much
wild.
That was the inaccuracy that I saw that jumped out, was the fact that I saw that I was left out when you had put the firm, the money wise. I did not, when I responded to that, it was for that specific reason.
Okay. And I agreed I would put that back in, that section back in, and I
Correct.
did. I did put it back in, and I sent it to you again.
I don't recall getting a second email from you, no.
But you were happy that I put it back in, or that I agreed to put it back in.
And object this to relevance.
Yeah, we need to get to more material aspects.
Yes, Judge, I'm moving along, I promise.
Mm-hmm.
So you did ask me to put that back in.
Well,
An answer relevance.
well, you didn't answer that last question, so overruled.
You did, can you confirm you did ask me to put that back in, for it to be accurate?
You know he don't
Yes,
remember.
that's correct.
Damn.
I said that, yes.
Look, he tired. He like fuck it.
And
I'm not can't.
Then I asked you if everything was accurate, and you said, looks good,
Give up.
Yes.
correct?
I recall you asking that, but the looks good was
speculation
applying to the accuracy of the
I said it,
74,000.
but I was speculating.
That's it.
Okay. So
guy.
when you reviewed the motion,
It's horrible.
and you specifically pointed out that one thing that you found inaccurate, you didn't point anything else out that you found inaccurate in that motion, though, correct?
No, I did not.
And that motion alleged that their relationship began when Ms. Willis was in municipal court.
If I can reread the motion,
Oh,
but I don't recall.
You
But
let-
if that's what it says,
That
but
jury finna get COVID so fast. They're like, I am not
There's no jury.
that
jury.
it looks good
Just the
was
judge.
when you put back
he's
in
about-
the
about to
74,000
have a family emergency.
into your
Probably have a
motion.
heart attack.
Okay, and that wasn't what I was asking. What I was asking is, you didn't tell me that there was anything else inaccurate in the motion, though, right?
But I didn't state that anything was accurate, other than It's 74,000.
Now, when I told you that I had this motion that I was preparing, you asked me to send a rough draft.
No, that's incorrect.
May I approach, Judge?
You may.
Which page are you showing?
They're not page numbered, it's,
She don't
January
say it
6th.
every time. I'm waiting for the bailiff to just tackle her. I'm like, yo, get her. Yo, she's lunging. Got a paper clip.
I know she's so mad at him right now. Like, come on.
I can still see the chat for the Atlanta news.
You can?
I got it open on another window.
Oh, okay.
These people are crazy.
Yeah, it's going. That's why I was like, I can't leave.
Oh
Distracted.
my God. These people
It's
are
going a
nuts.
mile a minute too. What are they saying?
It's
What they saying,
16.
Mike?
It's 17,000 of them in there
Oh
going
my
fuck.
You asked me to send you a rough draft, and I told you, okay, but I didn't
So
want it to be
many
leaked
emojis.
before I filed it.
That is correct. That is correct.
So you're the one that asked me to send a rough draft.
Yes. Stop lying. You're making yourself look real bad, dude. You gotta live after this.
They're
Yes,
talking
that's
about, I
correct.
don't
Yeah,
recall
yes,
in the
that's correct.
chat.
And that was at 10:08 on
You finally
Saturday,
admitted something.
January 6th. And then you got an email from me with that rough draft at 10:25 that same day, correct?
Yes.
If you need to look at it,
If it says 1025, then I know you sent me an email.
Ashley Murphy ain't gonna like the back shot pictures. You gotta get something
Why he's
smooth
looking
that
at it,
out, honey.
I'm going to object us to ask the name. We've
good.
been through the fact that he sent him a copy of the motion, whether
Long
he
back.
specifically said rough draft or not, and then asked about the accuracy. He's explained
Foundation
his
here
answer,
isn't.
and I've object to ask an answer. So.
Understood, Mr. Vaughn. We're getting there.
Dark
Overruled for now.
So tired of the state
and then
attorney.
I responded when we were talking about that footnote that we were just talking about. I said I took it out, but I can add it back, and you said yes, add it back. You remember that?
I answered that yes.
And then I said anything else, anything that isn't accurate, and you responded looks good. You recall that?
That's powerful.
Let me see the.
That's powerful. That's powerful.
I don't know where the exhibits are. They were admitted.
Why you don't know where the exhibits are? That's why we doing this long ring around the Rosie.
That refresh your memory?
Because it ain't organized.
It says looks good,
Remember,
but
remember Exhibit B?
as I stated before, I was responding to you putting me back into the motion for receiving $74,000 in a contract.
But that's not what this says. This says, you said yes, add it back, and then I said anything else, anything that isn't accurate, and you responded looks good. So you weren't responding to put it back in.
Your Honor, I'm going to object.
I
This
know.
is not his motion. He wasn't the affiant of the motion or verified. the contract.
Overruled, Mr. Vaughn.
Right, sit down. That's a stupid objection. He's not the affiant.
I've said twice.
Overruled, Mr. Vaughn.
I've said twice
Judge should say,
if it looks
you have a
accurate
standing
was, or I've said
objection,
more than twice,
do not object
was for
again.
the 74,000.
I heard you.
Right. She got it. She got something finally.
Do you remember telling me about
She gets something, damn it.
Nathan and Fawny coming to your office and spending time together at your office?
No, I mentioned, I do recall testifying on the 16th that she had come to our office.
And that was before she was elected as district attorney, correct?
I recall that that was when she was district attorney. Because I said that there was a meeting held at my office.
And who was at that meeting?
Now, I can't tell you that. I don't recall.
But you know Miss Willis was there and Mr. Wade was there.
It was at our office. Actually, Miss Willis was there, and there were other people there. Mr. Wade was not in that meeting. He was
You remember that, huh?
in the back.
Interesting. You
I
remember
wasn't
Yeah, you
in
were
the-
calling, bro.
Why did
Remember
she
what
hold it at
people
your
was?
office?
I have no idea.
A whole lot of recall you got
Tell
there.
you when you
You
want
also remember telling me about them spending time together at her law office before she took her job.
to. Just give
I
it up.
don't recall. Do
Give it
you?
up, man.
I don't recall. Do you have something to?
To
Well,
help
what I'm
me
asking
stop
is,
lying.
let's back up a
Anything
second.
to prove
So
that
Ms.
I'm
Willis
lying?
rented
No,
a law
then I don't
office
recall.
from
Right.
Evans, or Andrew Evans and another lawyer, I think Stacey Evans. You have knowledge of that,
I didn't
correct?
write that down, did I?
object to hearsay.
All right, yeah, I don't recall.
Right.
If
Well,
I got no
How does he know the
receipts, right?
information? That would be the correct question.
okay. Ms. Merchant?
I don't really know even how to respond to that. Hearsay, I'm asking if he knew that she rented
Yeah,
offices.
he may have been there. He may
Right.
have seen a business card or something.
So
at some point. I
overruled.
think you can answer that.
I've never been to Miss Willis's office when she was in private practice. I've never dealt with where she rented. I didn't even know where her office was. So
Do you remember, though,
don't
knowing
recall the
that
location.
she rented an office
yes,
from the Evans?
yes,
You did know that.
that is correct. Yes.
Okay.
Personal knowledge.
And do you remember telling me that Mr. Wade and Miss Willis would rendezvous at that office?
I'm gonna object,
Oh, I hate this guy.
Secret.
again, hearsay as to how he knows that information.
It's first he has
said
to know.
Personal knowledge.
He did
just-
not say
lying
he has no
about not
personal
having
knowledge, but She hasn't even
personal
answered it.
No, he said in general, he had no personal knowledge, so it's not been established the source of how he would know this, because he said he's never been to her
Gold
office.
crown, know what's up.
All right. Ms. Merchant, if
you remember
I know you're
some.
trying to impeach him by a prior inconsistent statement, but unless you can first back up and show why each statement is actually something that he had knowledge of, I don't know if this is going to be relevant.
And Judge, I'm not even there yet, but again, that a speaking objection, and so now I would anticipate what our response is gonna be next. I didn't ask anything that was objectionable, but these objections are coaching the witness. I asked if he had knowledge, that's it. I didn't ask, did someone say this to you? I didn't ask, what did this person tell you? I asked if you knew.
Well, no, you're asking if you had knowledge, and then you say of something specific. So,
Once I get
You
an
can't
answer to
ask
that,
if you
he
have
has knowledge, then I will follow up
general
with
knowledge.
where that knowledge came
all
from.
right, well, let's try again.
So my question is, do you have knowledge of them meeting at that office?
Objection, foundation.
Okay, all right, overruled.
Do you have knowledge of them meeting at that office?
I have no personal knowledge, if that's what you're asking.
I didn't ask that yet. I asked if you have
Any knowledge.
Objection, that would be hearsay.
Overruled.
Not if
No.
it came from
We
Mr.
don't
Wade,
know where it
Judge.
came from, so.
That's
you
right.
said- How do you know, Mr. Bradley?
How do you know?
Any knowledge that I would have received would have come from my client at the time.
Okay, so you had knowledge of this place that.
You
that
see the
Ms. Willis
judge?
worked.
He was annoyed.
What did you know about them meeting at that office?
Objection, hearsay.
It's not hearsay.
It's not. It's an admission of a party
How he
opponent.
knows it, and then you ask the next question.
All right, he's already asked the next question.
That's right. Answer it.
Can you repeat the question?
What did he
Yes.
tell you? That's the question.
How do you have knowledge? What knowledge did? Well, you just told us. You told
What
us Mr. Wade told you.
him
So tell
She
us.
forgot
what
the
Mr.
question,
Wade
too.
told you about
Merchant
Ms.
forgot the
Willis and
question.
Mr. Wade meeting at.
She all out of
Evans'
order.
office.
Right.
Her numbered questions are all fucked.
Objection, Your Honor, privilege. This clearly covers the time after December 2018, covered by privilege.
Yeah, overruled.
Thank you.
You recall the question, Mr. Bradley?
I do not.
What you sitting there
You asked
then
the question.
pondering?
What did you learn from Mr. Wade? I would clarify that's where you learned it from. About Mr. Wade and Miss Willis meeting at the Evans office together.
I want to object to asked and answered. He's testified
He
that
hasn't answered.
He answered
He hasn't heard an answer.
Thank
he
you.
testified he had one conversation with Mr. Wade in the back of
Oh my
law
God.
office.
Yeah, and his answer may change, so
Him
overruled.
off as to what, how to answer the
Shut up,
question.
Ashley. He overruled the objection. You don't need no. He don't
I
need your
can't
help.
recall what the conversation was. I do recall knowing that he would go down to the office or had been down to the office, but I can't tell you in what capacity or when or any of that. No,
Mr. Wade told you that they had sex at that office, though, correct?
I don't recall him stating that. No,
You don't recall.
no.
So it's possible he did say that. Just just don't remember one way or another?
I do not remember him saying that.
Damn it, what I miss?
Do you recall that he had a garage door
Well, it's
opener
text.
to either a
Texting.
house or a condo or something like that
I mean, I don't recall.
of Miss Willis?
More of that.
I've never seen a garage door opener. I've never been to Miss Willis's house. I've never been to, and I'm trying to explain, I've never been, so no, I do not have any personal knowledge of him having a garage door.
But did he
opener.
tell you that?
Let me ask the question again.
Yes, ma'am.
I didn't ask if you had personal knowledge, like as in you saw it. Do you have any knowledge at all from Mr. Wade?
That's right.
Source.
Nice try with
He
that.
had a garage door opener to access one of Miss Willis's residence.
And I'll object to any source as to hearsay.
It's not
All right,
hearsay.
depends on the source. Overruled.
No, no, I don't have any knowledge.
Oh, you lying.
So when you told me that, did you just make it up?
Do you have
Were you
something
lying
that
then or are
shows
you
that I
lying
told
now?
you that?
Right, where you lying then?
Well, we're going to go through all the texts we can, but do you, so was that made up
Is
then?
this a liar or you a liar?
I'm going to object because
I don't recall him having,
Mr. Riley, just a
I'm going to
second.
object under 106 as the rule of completeness. I don't have that text message or any text
Oh,
messages
now we
that
got the
indicate that,
rule of
Your Honor.
completeness. Okay.
And I don't
students?
have, if it was a text,
Rule of
we
completeness,
had
I
that
think that's
conversation. I
106.
actually think it was when he was on speakerphone and Mr. Merchant was there, but I'm not sure.
105
But,
and 106.
I mean, if I'm asked to qualify exactly where that's from, I would
Okay,
think.
so rule of completeness would be if you need to introduce other text to show the context. If you're saying you haven't seen a copy yet, then I think Ms. Merchant needs to do that before you can
And I don't
decide your
have,
next step.
and that's what I was asking him. If that was something he just remembers making up. If he doesn't, then that's fine. But
She referenced text messages and started to go into her packet of papers.
Sure.
that have text
So you don't
messages.
have a text message to that?
I would need some time to look through, and I don't remember if I have a text to that or if it was during a conversation. It was one of those.
All right,
And I'm-
well, he has now said that he has no knowledge, so on to your next question.
Okay. Did Mr. Wade tell you about the trips that he and Miss Willis took?
no.
You have any knowledge of the trips that he and Miss Willis took?
Objection, hearsay.
Overruled.
I do now.
He gonna wear that chair out.
Okay. But you did not before this proceeding?
I did not know until you text that you found that in the deposition of his divorce. I mean, not deposition, but something from his divorce.
Okay.
I see.
And
I was
when you
thinking that
responded,
I was watching the
doesn't
other day.
surprise me, they took many
Y'all
trips to
just be
Florida,
dating anybody,
Texas,
huh?
California. Those are your words though, right?
I'm going to object as to relevance. He said he did
How
not
does
know
he with
and he actually
anybody?
learned from Ms. Merchant the information.
He must be getting
He
paid.
said he
by the
learned
objection.
about certain trips from Miss Merchant.
Okay, you can tie it down, but
Thank you.
we'll
He
see.
had no information about any trips that Ms. Willis and Mr. Wade took. That he learned it all from Ms. Merchant. That was his testimony.
Sure.
Judge, I'm
Maybe
allowed
the conclusion we reach. I think she's going to ask more than one question, though. All right, Ms. Merchant.
And if, Judge, just so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Do you remember telling me that it didn't surprise you that they took the trips that I found in the divorce file because they took many trips to Florida, Texas, California? And then you told me that they took the trip to California when she moved her daughter there because she failed out of FAMU. Do you remember that?
You don't have to say that
I
part.
don't recall that, but if I don't recall.
Okay. Judge, may I approach? It's
Bailiff,
in one of the ones I gave you.
keep an eye on her.
Look at that. Let me know if it refreshes your memory.
Ike, I'm recording tonight. A new show for the network with two young black lawyers.
So when that,
All right. What time?
It won't go live yet. We recording the
Yes.
footage
Yes.
and all that stuff.
So it's true that you told
gonna
me
be
that they took many trips to Florida, correct?
Okay, you invited me.
per that, yes, but
I'm trying to
one
get
of the
them to
messages is cut
understand.
off, And you asked about some other trips, and I said, no, I didn't, I think. And that was specific to, at the top of that, it says, no, I didn't.
Yes.
And so that was to the trips that you asked me about. And I think before that, when you mentioned that you found all these trips, I think I said, oh, wow.
Yes, you did.
And
You did not know about all the trips that were taken, and
He
you
recalled
lied.
that.
You said, no, I didn't. When did it happen? And then the next text, which I can get, or you can look at your phone.
They
or
could. They was
whatever-
hiding that
whatever
from
refreshes your
everybody. Her
memory.
daddy didn't know either.
You said was
Remember?
after you
Her
left,
daddy
after
didn't
the
know they
firm
was
assault,
dating.
correct?
Object to relevance.
Overruled.
It was after the firm. The trips that you said no, you didn't know about. You told me those were after your firm had dissolved, correct?
I think you mentioned that they were after I left, maybe, or whenever you found them. And I said, no, I didn't know about those trips. So
So you believe I mentioned that it was after you left?
I'm quite sure you have the text message, and I will refresh my memory.
Should have had this shit ready.
Is it easier for
Ashley.
you to refresh your memory with your own phone or with my printouts of screenshots?
Well, you have the printout, so I'll have the.
Judge, the reason I'm asking
gonna
is because
help
I'm getting
you? What the
objections that
hell?
I've cut things off, and it's just the nature of how you have to print out screenshots. So in order to avoid that, I'm happy for him to refresh his memory with his own phone, if that would be,
Well, I don't know if he's accepting your offer or not. so-
Not.
would that be easier for you?
Not helping you.
You can just provide the documents.
Okay.
He's not doing
Yeah.
that. He's not gonna help you, Ashley.
My phone ain't got no charge. Wish I could help.
Right, can't
I'm
do
not
it.
helping you. You know the brightness don't work on this phone?
I didn't bring my phone. Actually, I didn't bring
I
it
don't
today.
recall if I brought my phone today.
I don't recall.
I don't recall my password. I'll have to email them later. It's my face. Oh, I forgot.
I have some water, Judge.
Oh, he needs water. You know what that means?
I'm gonna need a bathroom
Sorry,
break.
Judge, I'm just
If I
trying to
get
pull out
some more
all
water,
of this.
please.
You make me?
All right. Well, I don't really see, at some point, we're reaching the cumulative point where we don't need to go through an entire 6-month text chain. You're making the point that he made some comments to you along the way that led you to believe he had more knowledge than today. He's testifying that he had.
Say it, Judge.
And
Me,
so if you've
myself,
hit
and
the
I
high
like
points of
sweating.
that,
Yeah, he lost a lot of
then
water and electrolytes.
I don't know what
sweating
else
up
we
there.
can cover that actually moves the needle.
Okay, I'll move on to the actual trips then. So you told me that they took many trips to Florida. That refreshed your memory. You told me that. Was that based on your knowledge from Mr. Wade?
That would have been based on anything that my client would have told me. I didn't have personal knowledge of whether they went or not.
The trips to Texas, and you're the one that typed Texas. Was that based on your knowledge from Mr. Wade?
It would have been something that came from the client. I cannot tell you that I have any personal knowledge of any trip other than what would have been said by the client.
Obviously, and I'm not asking if you went on these trips. I'm asking if you have knowledge from Mr. Wade. You also typed California. Was that something that you gained from knowledge from Mr. Wade?
It would have been from the client at this particular point. Yes, it would have been from the client.
And when you told me that the trip to California was to move her daughter out there, would that have been something you gained from Mr. Wade?
Thank you, Judge. Any knowledge that I have of any trip would have come from my client at the time.
Yeah, they gave him a big bottle too. Oh, that's
Because you're going to be here for a while.
no little
You told us
airplane bottle.
last week that Mr. Wade used your credit card one time. Do you know when that was?
I do not.
Relevance. Why we're here today.
Well, I think this would be impeachment of Mr. Wade's testimony if Mr. Wade testified that he had never used anyone else's credit card before.
I'm object to asked and answered because it was covered
Oh,
during the last
God.
year where he acknowledged that Mr. Wade used his credit card.
Judge, I asked when.
Just
I didn't-
when, okay?
I didn't ask, did he? I asked, when did he?
Let's go there.
I don't know where you
I
got
do not
that
have
net worth
any
with $8 million.
dates
I don't know where you
of
got
when
that.
Mr. Wade used my credit card. I testified that we used the card for business and that throughout the business we would order paper or supplies or
Trips with our girlfriend.
filing of depositions. I mean, the cost factor of cases is what I said, and that still applies today. Did he use my credit card? He did. but I can't tell you who he used that card, what the trip was for. I can't even tell you at this time where he went.
But he used it for a trip.
Yeah, it was for a trip, but I can't tell you where, when, why, or anything to that nature. Correct.
And he paid you back in cash.
I never testified that he paid me back in cash. I said that he would either pay me back, I said I couldn't remember. I do not recall. Sometimes he would write checks. Sometimes he would pay cash.
I thought it was one
And that
time.
still applies today, that I do not recall him paying me back cash, but I do recall him paying me back.
And this was when you were still, before your partnership split up, correct?
It would have been before I left the firm, yes.
Obviously.
He wouldn't have used my card after I left the firm.
Right.
Okay. So we can at least narrow down the dates to that.
Of before I left the firm, yes.
Okay, great. And Mr. Wade gave you details about meeting Miss Willis in Hateville or East Point, as it was called.
That's incorrect.
He did not tell you about that.
He didn't give me details.
What he gave you, a big
He
picture?
did not tell you about meeting with Miss Willis at an East Point or Hateville apartment?
Is this town called Hateville?
Hate.
Who would want?
Hate.
I was like, who would want to live in Hateville? Like, that's a terrible city. Change the name.
At this time, I don't recall.
Terrible name for a fucking city.
No, I don't recall.
Yep.
Where did you get that information from then?
He's testified he doesn't recall if he even had that information.
Yeah,
I
don't
asked
put words
if
in
he
his
got
mouth.
it from Mr. Wade, and he says he doesn't recall. So then I asked where he got it from.
I do not recall where I got the information from.
Okay.
The judge is going to
And you and
disqualify
Mr. Wade
him.
were
You know
friends
that,
as well as
right?
business
This shit is
partners,
not going
correct?
to work.
We were friends in the sense of I've known him for years. Yes, we were friends.
And you definitely did not want to come and be a witness in this case, correct?
Absolutely not.
I don't recall.
That is correct.
And it was after, and we talked about this earlier, that Gabe Banks called you and then Nathan Wade called one of your friends. It was after that that you hired Mr. Chopra to assist you in this matter, correct?
Here we go.
Was it after that?
Bruh.
So I hired Mr. Chopra and I hired Mr. Graham. Now, Mr. Graham is here, and when I received the subpoena, Mr. Graham was here at the last hearing, but he also had to go out of town, but he was present. Mr. Graham, I called, and I had started getting calls from media, and I told him to
around the
respond to
mulberry
the
bush.
media, I think, and that was somewhere around whenever you subpoenaed me. So it was, I can't tell you that it was that instance of those calls for Mr. Chopra, but I had engaged Mr. Chopra and Mr. Graham at that time.
Okay. I'm going to ask the question again because I didn't get an answer to it.
Non-responsive.
After you got
Monkey
the phone
chased
call
the
from Gabe
weed.
Banks
Oh.
and from Nathan Wade to your
I
friend,
think it was before that, but however, I think it was before that, is what I'm stating.
when you got the call from Gabe Banks, you called me immediately. Well, actually, you texted me and then you called me.
I didn't call you immediately,
called me.
but yes, we did speak.
Okay. And you texted me about it as well.
That is correct.
Bruh.
And then we spoke after Mr. Wade called your friend, and we talked about that as well, correct?
That is correct.
And at that point, you didn't mention anything to me about being represented by Mr. Chopra.
But I didn't mention anything about Mr. Chopra or That is correct.
Yes, that was only my question.
Oops.
Right.
Let's see.
A little far out there on the ice.
I'll show you two more texts. They're in the ones.
All right, Ms. Merchant, we're going to do
This is the
5
last
more minutes.
2 questions. Thank you.
3:05, I'm cutting you off.
Thank you.
This is what court would look like if it was run by the NFL and they have to do a commercial every 30 seconds. The constant breaks. Just
May I approach?
done 5 questions. Bailiff? Nah, her.
She's had, but they started at 2:30. She's had at 2. She's had an hour.
Yeah.
And there are a dozen other lawyers waiting for their opportunity.
Go wrap that gavel up, B.
Okay. I mean, she gets first bite, I believe, because she started the process with her motion. She represents Roman, guys. She doesn't represent Trump.
Are these supposed to go together? Oh, these are two separate dates?
Is that the black dude?
Okay, all right.
Goes down there?
Huh?
Roman?
Well, I don't know. I don't know. I really don't know, honestly.
Let me see.
I don't know which one is which, who is who.
What's his last name?
Roman? Roman.
Yeah.
I think he's Roman. I think the last name is Roman. Let me see.
Roman Rico.
Trump co-defendant Roman.
Of course, there's a guy named Rico Roman.
But do you recall me asking you, do you think it
My
started
dumb
before
ass.
she hired him? And you said absolutely.
Mike Roman.
You recall that?
I see that in the text message, yes.
Okay. And do you also recall me asking you how they would react if they would attack me? And you said, no, they will deny it.
Your Honor, objection as to speculation.
They will deny it, and they did.
How he thinks they will react.
I think that goes to the motivation.
That's right. I think it does too. Overruled.
And you told me that they will deny it.
That's written in there, yes.
No, that's not. That's
I just
written.
want
That's what
to,
you
one
said.
last opportunity. You're an officer of the court, correct?
I am.
And you're under oath today?
I am.
Is there any of your testimony from today or the previous days that you want to correct?
That I want to correct?
Yes.
No, I told you everything that I've answered everything that you asked.
Thank you. Oh, Judge, just so the counsel and the state can have them, just for the record, I can admit those few that I told. That would be.
Well, they were never tendered,
And
so it's just for,
I didn't know if they wanted
right.
to use them, but I'll hold on to them.
if they need to be tendered at some point, then we can make them part of the record. All right, let me turn over to Mr. Sadow, if you're with us on Zoom.
Thank you, Your Honor. I do have a few questions. First thing I'd like to know is whether the court reporter has defense exhibits 26 and 27 from the last.
We have a different court reporter this time. We had to have someone else fill in on such short notice, but I can potentially send those to you if you need them.
Well, I think I have working copies, but I want to make sure that the witness has a copy to look at.
All right, we can try to work through that logistical challenge. This is, you said 26 and 27?
I believe that's correct. And 26, I think, is the same text messages that Ms. Merchant was just asking me about. It was 2 pages. I stapled it together, and it is dated January the 5th of this year.
Right. That's what I just checked.
He's the Roman
I can print off a
Catholic.
copy now, but why don't we start
with
off
8
with the questions that you have?
Okay, because that's where I want to. That's where I'm going to start, but I'll see what I can do to work through it.
Racketeering, conspiracy to commit impersonating a public officer, conspiracy to commit forgery in the first degree, conspiracy to commit filing false documents, conspiracy to commit false statements and writings.
All of that.
All right, Mr. Sadow, why don't we start
She
with
over
your
here
question,
like-
and we'll see if we actually need to get a copy of those exhibits in front of the witness.
All
When
right,
did they eat crab legs?
Mr. Bradley,
All right, lady.
Yes, I'm here.
all of a sudden I've lost you on the screen.
Was it garlic butter?
There we go.
All right,
Now we're
sat
on the
down.
Zoom.
Here we go. Come on, Steve. Get in that
You're on
ass.
YouTube, but you're not on the Zoom itself. But not that I can see.
They need a producer. They should have called me.
I'm here. I can hear you.
No, I know. I think
I
his
thought about
visuals
that.
may be a little different, so hold tight, Mr. Sadow. We could try to correct that.
For
Yeah,
client
Yeah, he
work?
was on. He was on when Ms. Merchant was asking questions.
We need to
Be
add,
able to see you.
I know, we need to add a spotlight to to the witness stand and a spotlight to Mr. Sadow, and we don't need all the other boxes.
Like I thought about doing some
There we
work
go.
reports, but then I'd
Thank
have
you
to
very
look
much.
into
So
them
the whole time,
cases.
Mr. Sadow, we need to add you as well.
No, sir.
That's painful. Yeah, that's painful.
Nope. I need my mental health, baby. Not listening to that every day.
All right, now we're ready.
Thank you,
Paint
sir.
me like a judge, then.
Mr. Bradley, you have referred to Mr. Wade as your client, correct?
Correct.
But he's your friend.
You understand that the court has ruled that communications that you had with Mr. Wade are not privileged, correct?
What are you looking at them for?
No, I'm aware that the court ruled that one specific dealing with the time frame of one specific conversation wasn't privileged.
Then I'm going to ask Your Honor, if it's at the limitation or
Excuse me.
We need some clarity on the
To
parameters.
clarify,
email.
sure, Mr. Sadow, you asked whether all communications with Mr. Wade, I think, were covered. That was not the extent of the ruling.
Okay.
The only ones that I deemed were not covered, and that I'd asked about in the in-camera hearing, because those are the ones that were relevant, were any communications Mr. Wade made regarding the existence or non-existence of a romantic relationship with Ms. Willis.
Fine, thank you, Your Honor. I
Fair
understand.
enough.
So going back to this line of inquiry, when you say you don't have personal knowledge, what I want to ask you to start with is very simple. Did you have communications with Mr. Wade about the relationship between Mr. Wade and Ms. Willis? It's a simple
Yes
yes
or
or
no?
no.
I don't recall. Boom. Next.
Yes.
No, that's a yes.
Okay. And is it your testimony that during the time you were representing him, which I understood started sometime in 2018, is that correct?
That's the time frame that I remember, yes.
Is it your testimony under oath that with regard to conversations with Mr. Wade about his relationship with Ms. Willis, that you only had one such conversation during the time you represented Mr. Wade?
One conversation of what? I apologize.
I don't know what you mean.
The only thing we're about, the only thing I'm asking about is that area that the court said is not privileged, which is the relationship between Mr. Wade and Ms. Willis. You've testified that during the time you represented Mr. Wade from 2018 on, that you only had one conversation with him in reference to the relationship between Ms. Willis and Mr. Wade. Is that correct?
Yeah, I think that's fairly accurate, yes.
That don't sound true.
Okay, so out of the entire time, I'm talking about could be 2018, 2019, 2020, 2021. When did you stop representing Mr. Wade?
Timeline down.
It was a few months after I left the
When did
firm.
you leave the firm?
All right, give me the approximate time.
I left maybe June, July of 2022, maybe.
Okay, so that would suggest that for, assuming it's 2018, 2019, 2020, 2021, and half of 2022, which is in the vicinity of 4 to 4.5 years, you're testifying under oath you had one conversation about a relationship between Mr. Wade and Ms.
Lock 'em
Willis.
down,
Is
Sadow.
that correct?
Think about that hard, buddy.
Better
I
not
don't
recall.
recall having
There
any
you go.
other conversation with Mr. Wade
Better
about him and Miss
You have any
Willis.
conversation with anybody else?
Is it your testimony then that you don't remember any other conversation, or there wasn't any other conversation
That's the
besides the
difference.
one?
An objection is to ask and answer.
No.
I think he's drilling down. I
Not.
think that's a
Thank
fair
you.
question
Fair
overall.
question.
I don't recall. I would say it was
Golden
the
crown.
one, but I don't recall.
Again,
You testified that you did have communications with Mr. Wade about him visiting with Miss Willis at a condo or apartment, correct?
I don't think I testified that I had a conversation. I testified that any knowledge that I would have known anything about any condo would have come from that, but I don't recall a conversation about that. I do not recall a conversation about that.
Do you recall any other thing
Gold
at this
Crown
point in
OLI.
time
I don't know
oath
much.
that would indicate when the relationship started between Mr. Wade and
Not
Miss
giving you that.
Willis?
I do not know when the relationship started between Mr. Wade and Miss Willis. I cannot recall
so
that. I can't. Oh, I'm sorry. Go ahead.
I'm going to drill down on that now, okay?
Yes, sir.
Sat out using the judge's word.
Mr. Wade was hired as the special prosecutor on November 1st of 2021. You're aware of that, correct?
Of course you are.
I have my contracts to show when
Oh,
I
get the
started.
fuck outta
No
here.
one showed me the contract of when he started.
Just
but,
disqualify him,
so,
Judge,
but
already.
if he has a contract for November 1st of 2021, then that's correct.
I'm going to suggest to you that the record will reflect that the
you're a liar,
contract
sir.
between Miss Willis and Mr. Wade was November 1st of 2021, correct? I want you just to accept that, okay?
Oh, no objection?
Is it your testimony that you don't know under oath whether or not there was a relationship between Mr. Wade and Miss Willis before the contract?
You gotta know.
I do not recall any dates of when the relationship started. So whether you are pinpointing a date of when his contract started or not, I'm telling you, I did not recall any specific date that he flat out said anything about a relationship with Miss Willis.
Okay. Now I want to go, based on what you've just said, let's go to what was Defense Exhibit 26. Okay? In Defense Exhibit 26, which I showed you last time, was 2 pages of text messages between you and Miss Merchant, correct?
Correct.
All right. Now, the first page starts off by saying, Miss Merchant, like, just date, don't hire him. Do you think it started before she hired him? You see that?
Nope. Forgot my glasses.
He's right there. You don't get to say no.
Yes, I see it. Yes.
And your response to that
Absolutely.
was absolutely, correct?
I'm going to object, ask and answer.
Fuck you. Absolutely.
Ms. Sato, I do think we went through a lot of these texts.
We didn't go through this whole one.
Just a second, Ms. Sato. All right.
Somebody about to get it.
I'm sorry, Ms. Sato. You said we didn't go through this particular one?
No, we stopped right there. I want to go.
I answered because this is the exact language that she just stated a few minutes ago. You could read it back.
Okay, Ms.
in the
Sato.
record.
You saying both of these 2 exhibits weren't already covered by Ms. Merchant?
It was not gone, this particular language was not gone into. I'm doing it based on the exhibit itself. Well, let's do it this way. I now move into evidence defense exhibit number 26.
Put it in evidence.
All right, and I don't have, I'd have to search through my notes, but does anyone recall that one actually been tendered in a minute already?
It was.
No, it was only presented to your honor
identified.
for you to take back into camera ex parte to speak with Mr. Bradley and his counsel.
Okay. Ms. Merchant is indicating that it was admitted.
She's a space cadet.
But I'm organizing.
Don't listen to her.
back in order.
Do not listen to her.
I think it might be easier if I just admit the copies.
I did not hear it be
All
tendered.
right, so Defense Exhibit 26 and
Easier if she did
27 are being tendered.
Objection.
Well, actually, only 26 at this time, but
Okay, Defense Exhibit 6, any objection from the state?
Of course.
26.
26.
I'm going to object as it relates to foundation and authentication. It was used to, during the last hearing for the purposes of.
For my students
refreshing
watching,
his
authentication
My
901.
recollection is that it didn't refresh his recollection, but I would renew my objection as to asked and answered in cumulative
Okay. As to foundational authentication, I think Mr. Bradley has recognized them as text that he sent and received. So
He recognized it, so it's substantially what it purports to be.
On that basis, any other objections to
That's
their
satisfied.
admissibility from any other
Authenticity.
defense counsel? And seeing none, Defense Exhibit 26 is now
It's
admitted.
admitted.
Mr. Sadow.
Thank you. All right, let's continue. Now I'm publishing it. After you said the word absolutely, on your own, you said it started when she left the DA's office and was judge in South Fulton.
You said that.
They
Your
met
words.
at-
Aw, man. Come on, bro. You're
Understood,
going to
Mr.
have to
Body.
start
I'm going to let
recalling.
Mr. Sadow have a few minutes on this, and we'll go from there. But
Judge, well, I'm sorry. I did answer this. I answered it for Ms. Merchant. I stated that I was speculating. The judge, someone objected to the speculation, but this was the exact same language.
All right, well, thank you
when
for
I
that
said
recap,
that
Mr. Bradley. Mr. Sadow was asking the question in a slightly different manner, and I'm going to give him a little bit of leeway to do
I
that.
love this
So,
judge.
Mr. Sadow.
All right, I hesitate to have to start back where I was, but
Do it, Sadow.
after the word absolutely,
Absolutely.
you on your own said it started when she left the DA's office and was judge in South Fulton. They met at the municipal court CLE conference.
Those are details.
That's what you said, correct?
Told y'all ain't been fucking since that conference.
It's your testimony, at least so far, that when you on your own gave those two statements in the text, that you were merely speculating and did not have that knowledge from Mr. Wade. Is that your testimony under oath?
I be speculating.
Yes, that's what I testified to. Yes, sir.
Wow.
I be saying
So
shit.
you on your own came up
with the
with
details.
the whole notion that it started when she left the DA's office and was judge in South Fulton. That's, according to you, that's speculation on your part, correct?
Overruled.
I got it wrong. That's my
Answer
fault.
the question, Mr. Bradley.
Yes,
I'm allowed to
that's-
be wrong.
That's
And so-
speculation on my part.
Lock
Yes.
him to a time, Steve.
Right. It had nothing to do with what Mr. Wade had told you, correct?
I answered
No, I
your
made that up.
question. I was speculating to the answer. That is correct.
So maybe you can tell the court in your own words, why in the heck would you speculate in this text message and say that it started when she left the DA's office and was a judge in South Fulton? Why would you speculate and say that in a text?
I knew they had met at the municipal court
you knew something.
conference.
You said you had no
How
personal
do you know that?
knowledge.
I'll stop you right there. How did you know that?
Got him.
I answered that the last
not.
at the last.
I'm
I knew
asking
that.
you now.
I knew that
Sir,
because
I'm asking you now. I'm asking you questions, and you are in a situation where you get to give answers. I'm asking you, how did you know that?
How did I know when they met?
Somebody told you that, right?
When they met?
A little
Yeah.
bird.
Yes, correct.
Who told you?
Mr. Wade told me when they met.
So you had more than one conversation about the relationship between Mr. Wade and Ms. Willis because he told you where he met her.
Yes,
correct?
incorrect. Incorrect.
It's incorrect.
It's incorrect.
Same conversation.
Okay.
Maybe.
Let's go back to the exhibit. Why would you speculate that that's when they started the relationship? What would cause you to put that down as speculation?
The basis of your
I
speculation.
don't recall, but why I thought that it started at that time. But I do recall that he only met her, and I testified to that he met her at that conference, which was in 2019.
You knew that Ashley Merchant represented a defendant in this case when you were text messaging with her, correct?
Yes, I did. Yes.
And you knew that the reason she was asking you questions about Mr. Wade was because she was trying to show when the relationship began, correct?
No, that's not.
Okay, what did you think then?
100%
It's not. Look at the
correct.
beginning of the text message.
Don't let him out of it.
Yes, but what
Text message-
messages were before this message, before she sent that?
I can't answer that question because I don't have
You
them.
don't get to
All
ask
I
the
have is
question.
what's in front of you.
Yes.
And it says that she says, do you think it started before she hired me? So you knew, as the counsel for a defendant in this case, that Ms. Merchant was asking you specifically about the knowledge that you had regarding the timing of the relationship between Wade and Ms. Willis, correct?
I mean, based on this, yes, I see what was asked.
And in response to that, you answered directly on your own what you now claim to be speculation, right?
That's correct.
So I ask you one more time before I move to the next part of this. Why would you speculate when she was asking you a direct question about when the relationship started?
I have no answer for that.
Except for the fact that you do in fact know when it started and you don't want to testify to that in court.
Overruled.
That's the best explanation, isn't it?
This is completely
Overruled.
argumentative.
Overruled.
He already cut you off, homie.
That's the true explanation.
Right.
Because you don't want to admit it in court, correct?
No, I have no direct knowledge of when the relationship started.
I'm not going to go back through that
Please
again.
don't do it, because he's.
But if you didn't know, and you were asked specifically as this exhibit shows, maybe you can explain why you wouldn't say,
I don't know.
I don't know.
I don't know. He gonna say that now. Say I don't know. I didn't say I don't know.
I don't know why I didn't say
Is
I
that a
don't know.
question? You're asking me a question to answer?
Definite,
Yes. Why didn't you
definite
say
question.
I don't know?
State that again, I apologize.
If you're being asked, as we've just gone through with this text message from Ms. Merchant,
Yes.
as the attorney for a co-defendant,
Yes.
and she's asking you about the relationship, and she's clearly asking you about the timing, why wouldn't you just have said in response, I don't know when it started?
I don't know why I didn't say I don't know.
Just say you hate.
Maybe,
Nathan Wade.
again, it's because you know what the truth is, and that's why you answered exactly the way you did in Defense Exhibit 26, correct?
No, I can't sit here and tell you that what you just stated was correct.
Right. What you want the court to believe, and you want the rest of us to believe, is that for some unknown reason, upon being asked a direct question about when the relationship started, you decided on your own
Speculate.
to simply speculate and put it down in a text message as opposed to putting down what you actually knew. That's what you want the court to believe, correct?
Yeah.
That was a lot. So can you break that down? I apologize. You're asking me, do I want the court to just
To believe that instead of saying nothing, you decided on your own to speculate.
Specifics.
Yes, I speculated. Yes, I've stated that I speculated. Yes, sir.
That's what you want the court to believe, correct?
That's correct.
Okay, now, then when you go to the next page of that, okay, you see it starts, the best that I can see, it starts in South Fulton. Is that what you have in front of you? Second page.
The second page that I have says that's what I figured.
Okay, that may be cut off from the one that I have. I'm looking at my opening line says in South Fulton. Is that on your second page?
No. So if you're going in order of the pages, no, neither page starts with South Fulton.
No, don't get caught up on whether it starts that way. Does the second page have a line in there that says in South Fulton?
Oh, yes, I apologize. So, yes.
That's fine.
Yes.
Just want to make sure that we're on the same page.
Yes.
Okay. You say after in South Fulton, they met at the municipal court CLE conference, right?
Yes.
You see that?
Yes, that's correct.
And then Ms. Merchant says, that's what I figured when he was married. Is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. You see, that's what she said, right?
No, I mean, so it says they met at municipal court CLE. The only other thing here says that's what I figured when he was married. There's no response for me on that day. And then there's another response, I guess a question that says, is this accurate?
Okay, that's what I just went over with you.
Okay, so I don't have anything in that, is this accurate at all? I can show the court.
No.
It just says, is this accurate with the question mark? I don't have anything following that.
You don't have, after that, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time?
I apologize. It goes to the next page. I apologize.
No problem. Just want to make sure.
So
that
I see that now, yes.
All right, so that's what I just read is exactly what Ms. Merchant said to you in the text, right?
Yes, that was in the text. Is it accurate upon further information? Yes, that's there.
And again, since you have told us that you were speculating when you gave the answer that we went over with previously, on this one, you don't say, I don't know. You simply correct her by saying no, municipal court, right?
Yes, so she asked, was it accurate? And I said it wasn't accurate. No, it wasn't accurate. It was municipal court.
Right, and when you said it wasn't accurate, it was municipal court, you didn't say, no, that's not accurate. They didn't start a romantic relationship at that time, correct?
No, but I was referring to the municipal court. No, it wasn't accurate as it applied to the, I was answering the no municipal court, meaning when she said, is that accurate, it was to the municipal court and not magistrate court.
Okay, but you didn't say that the rest of what she asked you was accurate. You didn't say, no, that's inaccurate. That's not true. That's not accurate. You simply said the only thing that wasn't accurate was municipal court should be there instead of magistrate, right?
So I was answering the question of, it was a compound question. And I was answering the question of, she wrote magistrate court and I said no, municipal court.
Right, but it's not compound. It's one statement upon information and belief. I'm sorry.
No, that's okay. I know the feedback and the delay complicates things,
Right,
but
that's what the
I think you've
problem is.
adequately
You gotta
made your
slow
point. I
down.
don't think we need to belabor it much longer. Let's move on to the next issue.
You got lag.
Thank you, Hunter. Mr. Bradley, prior to coming into court today, did you and your lawyer meet with anyone from the district attorney's office?
No. I mean, no. Not that I know, I'm aware of, no.
You don't know if you met
I did
with
not meet to anyone.
Fuck?
Sorry.
I did not meet with anyone outside of my attorneys.
Did you have any conversation?
I did not.
Meeting, conversation.
I did not.
So you have not spoken, if I understand you correctly, prior to coming into court today, you've not spoken with the prosecutors,
No.
right?
I've not spoken to the prosecutors. I've not spoken to defense.
Have you spoken to Mr. Wade?
No.
So as far as just getting into the courtroom today, there's been no contact or conversation in it with any of the parties we just went over, right?
There has not been any contact with defense or the state at all.
This is some nasty work. This is nasty work.
Trench work.
Yes.
I think I have basically just one or two more questions.
Okay.
Why would you see the need to speculate when you were
Let that shit
texting
go.
with Miss Merchant?
I think we did cover that one.
Let it go,
Mr.
Steve.
Sadow.
Come on.
He said one more bite at this apple.
Right,
I think
I gotta
that
go
question
back
was already
one
put to him.
chance. One more again.
Well, why
What
would you?
what would be the next one?
He's incredulous. That's why.
I'm
He's
trying to
incredulous.
look. Let's go to
What would
27.
cause you to speculate?
Right, right.
When you speculated, what was your mindset?
Defense Exhibit 27. Do you have that now, sir?
I do, sir.
Right, 27. That's the text
Would you look at it and tell me whether or not the Defense Exhibit 27 appears to be accurate? Because I want to seek to introduce it into evidence.
901 authenticity, guys.
It consists of an email to you from Ms. Merchant and a text response from you.
Remember,
correct?
the evidence has to be what
But
it
the text
purports to
response
be.
was not in response. So yes, it does consist of the email and a text response. I'm not saying that the text response applies to the entire email that was sent.
All I've asked you right now
Is to identify this shit.
are the
Yes.
That
is
it?
the email
Okay.
and the text, are those accurate in the interaction that makes up Defense Exhibit 27?
As it applies to the stapling of the email and the stapling of a text message chain, yes, that is Defendant's Exhibit 27. This is, it's accurate.
Okay, move it into evidence.
Okay, I would move Defense Exhibit 27 in. I believe it was treated the same way as 26 last time.
No objections, Mr. Abadi?
Yes, Judge.
Overruled.
All right, overruled. Any other objections from defense counsel? Seeing none, defense exhibit 27 is admitted.
He should be defeated. He should have never signed up for this shit.
All right.
Anything else?
Your Honor, I don't know. Yeah, I don't know whether you'll find this objectionable or not. I'll ask it, and obviously.
All right.
Well, why would you speculate?
Mr. Bradley, you realize that if you were to testify under oath, that you knew from Mr. Wade that the relationship between him and Miss Willis existed before the contract in November 1st of
jamming them up.
2021. That if you testified that you knew that from Mr. Wade, that would show that both Miss Willis and Mr. Wade
Lied.
had lied under oath. You know that, don't you?
I'm going to object.
I think that's going to call for an opinion on the credibility of another testifying witness. So I don't think that would be an appropriate question.
Then that's all.
Tried it. You
Thank you,
tried
Mr.
it.
Sano. Mr.
You
Stockton.
tried it.
Just briefly, Judge.
We'll see.
Next.
Mr. Bradley, do I understand from your
I'm
prior
gonna
testimony
run. Little
that
mama's waking up.
Ms.
She's
Merchant
hungry.
sent you a
Okay.
motion to
See you
review
later. Thanks for
prior to
joining.
her filing it?
Yes, objection. Call some cumulative answers.
Right. I'm going to give him just a little bit. All right, Mr. Stockton. Maybe this is going somewhere else.
Did Mrs. Merchant send you a motion prior to January 8th of 2024 for you to review?
That is correct.
And did you in fact review that motion?
That is correct.
And did you indicate to Ms. Merchant that the contents of that motion seemed okay to you?
Ask and answer it.
Well, so you're referring to Exhibit 27, which, as I stated a few minutes ago, one is an email, one is a text chain. So in the text chain, when I never responded to the email, I never responded looks good or anything to the email that was sent to me. However, in the text chain, what you all are trying to merge together is the fact that I was asked about the contract. And that contract was $74,000, and me being added back to that. So when I said, and I think before that in that text,
All this explanation. You hear?
it
He hasn't
referred
talked so
to
much since he been here.
me being added back, and at that time I said yes, looks good.
And you're aware and you recall that when Ms. Merchant presented you with that motion, she asked you not to disclose it to anyone until she filed it. Is that correct?
We are covering, I think, the last 5 or 6 questions. We've covered ground. Let's get to that ultimate point.
I'm trying to get there, Judge, I promise you.
Okay.
Judge is like, come on. We got an hour and a
Repeat the
half
question,
in.
I'm sorry.
She asked you not to disclose that motion to anybody until she filed it, correct?
I think so. I think that was in the text message, yes.
And you knew, in fact, it was her intention to file that motion, correct?
The actual motion that she, that was sent?
Yes.
Emotion
I knew that she was going to file a motion, yes. I do not think that that was the final draft, or it could have been that she was working on it, but yes, I knew that she was going to file some motion, yes.
And you knew that she presented that motion to you for your review so that she could make sure it was accurate, correct?
Your Honor, I'm going to object. All this is asked and answered in cumulative.
All right, noted. I think Mr. Stockton's getting to the next point, so why don't we just ask that one?
Is that correct?
Did you?
Why don't we combine that with the next question, so we're not having to lay bit by bit every single time?
Mr. Bradley, you knew that Mrs. Merchant was relying on your review to ensure the accuracy of that motion prior to filing it, correct?
Speculation as to what he knew that Miss Merchant knew.
So can he answer that?
I'd overrule that.
He can answer.
Mr. Bradley?
No, so
Yes or no? It's not,
once again,
doesn't require
I was
maybe.
excluded from the footnote of that motion. And my review of it, and I said, hey, you need to add me back to the footnote because I did have a contract and I did receive $74,000.
If I may help you out, let's talk just about that part of the motion that deals with the relationship between the District Attorney Willis and Mr. Wade. When you reviewed that, you knew that Ms. Merchant.
No, I did not know that she was relying on me relying on me for any accuracy other than what was put in there.
I'm
About
good with
74,000.
absolutely. The relationship
Mr. Bradley,
started.
if there was something
absolutely.
patently false in that motion, you would have told Ms. Merchant, wouldn't you?
I can't say that I would or wouldn't
Wow.
have. I don't know what I would have told Ms. Merchant.
If there was something patently speculative, you would have told Ms. Merchant, wouldn't you?
I don't know what I would have told Ms. Merchant. She asked me, was it accurate?
When you said looks good.
We were discussing the $74,000 that was left out.
Again, if I may direct you just to that portion dealing with the relationship between Mrs. Willis and Mr. Wade. You didn't tell her that there was anything patently false in that because you didn't see anything patently false in that motion as it relates to the relationship.
Repeat your question, I'm so sorry.
You did not inform Mrs. Merchant that there was anything patently false in that motion that you were presented with as it concerns the relationship because you did not see anything that was patently false, correct?
Objection asked and answered cumulative.
All right, next question, Mr. Stockton. Sustained.
And you didn't see anything that was speculative in there either, did you?
Sustained. Move on.
I know, sustained, Mr. Stockton.
I just want to ask you one more question.
It's got to be almost over.
I'm coming at from the other way that Mr. Sadow did. Did anybody from the district attorney's office or any witnesses in this case contact you about Ms. Merchant's motion from January the 8th of 2004 until today?
Did anyone contact me about her motion?
Yes, from the district attorney's office or any witnesses or anybody else involved with the case besides the defense?
Other than the only personal call that I had was with Gabe Banks. I never spoke to anyone else, and to my knowledge, he's not a part of this, so.
That's all I got, Judge.
Thank you, Mr. Stockton. Mr. Durham, if you're still with us.
No question, John.
Thank you, sir. Mr. McDougall.
No questions. We're over. Which would be good. Nope. Don't ask the same damn question.
Good afternoon, Mr. Bradley. You have certain information about the relationship between Mr. Wade and Ms. Willis that is not privileged, correct?
Well, that was my determination.
That's right.
So
Why are you
I think he
asking him
disagrees
that?
with it.
Come on.
So we're going to say his opinion's a little irrelevant on that point.
Do you understand that the court has ruled that certain information that you have
We've been
about the
over that already.
relationship between Ms. Willis and Mr. Wade is not privileged?
The court's ruling, as I understood it, and as my lawyers and I understood it, of the privilege not existing was based off of a conversation that was had in my office, in the back of my office, which was confidential, with Mr. Wade and I.
Quite.
That's what was asked of me on yesterday, and that's what the ruling, to my knowledge, unless I'm being corrected here now and saying that it's more, it was that particular piece that the judge said did not have privilege.
And have you testified already today to the sum total of your knowledge of the relationship that is outside the scope of the privilege according to the court's ruling?
Can you ask that again? I'm sorry, I didn't understand it.
Referring to what you understand to be the information that is not privileged, have you testified to the sum total of that information?
I think I have, yes. I think I've testified to that, yes.
All right, sir. That's my questions.
Thank you, Mr. McDougall. Mr. Rice.
Mr. Bradley, at least as of February 15th, when you first testified, you said that you still considered yourself a
Uh-oh.
I think I said that, yes. I think I did, yes.
And you've been friends with Mr. Wade for over 10 years, correct?
That would have been fairly accurate, yes.
And you recall communicating with Ms. Merchant about this case and about Mr. Wade and Ms. Willis's relationship, correct?
Why would you communicate with Merchant if that's your friend?
Answered and cumulative by all three of the previous.
Sure. We don't delay that foundation. Why don't we combine it with the next question where you've got a new point to make?
Okay. Mr. Bradley, when you communicated with Ms. Merchant, did you tell her any lies about Mr. Wade and Ms. Willis's relationship?
That's a bad question. Did you tell her any lies? I would object to form. It's confusing.
Did I lie to Ms.
What the fuck you asking me?
That's a simple question, Mr. Bradley. You're a lawyer. Did you lie to Ms. Merchant when you told her facts about Mr. Wade and Ms. Willis's relationship?
I was speculating.
Not that I recall. I don't recall. I mentioned earlier that I speculated on some things. I've testified to what I did know, so I can't recall whether or not
I lied? I can't recall if I lied? The fuck?
No.
Mr. Bradley, speculation is kind of a weaselly lawyer word. Let's speak truth here. You're under
objection. I've been argumentative. Argumentative.
Mr. Bradley.
Let's find a question, Mr. Rice.
Mr. Bradley, when you were communicating different details of the relationship between Ms. Willis and Mr. Wade to Mrs. Merchant, did you lie to her about any of those details?
Objection asked and answered twice.
I don't think he's answered it yet.
I don't recall ever
He's a liar.
whether any of it was a lie or not.
What?
Well,
This time, so.
at the time you were communicating with Ms. Merchant, you were still friends with Mr. Wade, correct?
You don't know if you were friends? Were y'all on the outs? And so you was like, I'm gonna bury this fool, and then y'all became friends again?
Yes.
And at the time you were communicating with Ms. Merchant, you knew that she was talking to you in her role and capacity as an attorney in this case, correct?
Correct.
And you knew that she was going to use that information to somehow benefit and file a motion, benefit her client, correct?
I did not know that.
Okay,
So I did not, well, I'm sorry.
So as an attorney yourself, you are testifying here under oath that you had no idea what Miss Merchant was going to do with all the details that you were giving her about Wade and Willis's
She was
relationship.
just gonna put him under a pillow.
So at the time, no, I did not. I knew that Miss Merchant was gathering information.
For what
That is
purpose?
correct.
Okay. And did you lie to her when you told her that the relationship began before 2020?
I don't think we need to drill into
We don't need to
specifics.
do
He's
this
covered
again.
it at a high level. I don't think we're
The
going to
judge
get
is
much
like,
out
we're
of
not
this.
doing this again.
Mr. Bradley, isn't it true the only thing that has really changed? Well, you were speaking to Miss Merchant, whether by text or by telephone. You never said to her that I don't remember or that I'm speculating, correct?
Good question.
I don't recall.
No, you never
Well,
said
you've
that.
looked through a whole lot of text messages.
never
Do you
said that.
remember ever seeing any communication from you that said, I don't remember?
Impeachment by omission, students. Impeachment by omission. You can
Yeah, through the messages that, I don't have all the messages in front of me, but no, I don't recall if I ever said I don't remember.
Do you recall seeing any text messages where you replied to her or gave her details where you said, I am speculating about this detail?
No, I never used the word speculating, no.
And the only thing that's changed between then and now is that phone call from Nathan Wade's friend, Gabe Banks,
Gabe
correct?
or Banks, yeah. Banks.
No, well, Gabe was my friend, and I actually stated that the first day that I was here was that I've known Gabe for a few years, and that we were, not were, but we are fraternity brothers. And so I never said that that anything changed behind Gabe Banks.
So you never told Miss Merchant that you were worried that they were threatening you?
Objection asked and answered when he was asked this on February 16th and today.
Mr. Rice, we've covered this.
We do? I don't remember that.
And just to be clear, you didn't attend college with Mr. Banks, did you?
I did not attend college with Mr. Banks.
When you referred to him as your fraternity brother, y'all just both happened to have pledged the same fraternity, different colleges, different chapters.
Well, that's what we consider fraternity brothers, yes, sir.
And as a normal course of your relationships with your friends, do you pass on lies about your friends?
What? I missed the question. Shit.
Have I passed on a lie about a friend? Is that what you're asking?
Is that something you normally do, Mr. Bradley? Do you tell lies about your friends?
Have
recall?
I told lies about friends?
I don't recall.
I could have. I don't know.
Do you tell lies about your friends about a
Motherfucker, yeah.
case of national importance?
Objection as to
Overruled.
I could have. I don't know.
Mr. Bradley, I notice you're not looking at me.
I'm looking at you on the screen only because I was accused of, and I did the same thing to Mr. Sadow when he was on the
What's
screen.
the next question, Mr. Rice?
No further questions, Judge. I think it's clear.
Thank you, sir.
Ready
Mr.
to
Gillen.
rule. I'm ready to rule. Any more? That's it? That's the last?
Good afternoon,
Oh, shit.
Mr. Radley. A few questions.
11?
A lot of folks have
Lawyers?
taken up the questions that I wanted to ask, but I've got a few left here.
We'll see.
We'll see. You said Mr. Radley, you said you didn't know what Ms. Merchant was going to be doing with the motion that she sent you. You remember that testimony a few minutes ago?
I think I said I didn't know that. I knew that she was gathering information, yes.
Well, let's look at the title of the motion that she sent
That you reviewed.
Do you remember reading?
That was sent on the 6th.
Excuse me, do you remember reading the defendant Michael Roman's motion to dismiss grand
disqualify.
jury indictment as fatally defective and motion to disqualify the district attorney, her office, and the special prosecutor from further prosecuting this matter? Do you remember seeing that in the draft that you read and reviewed?
Yes.
So when you tell this court that you didn't know what she was up or what she was going to do, she kind of gave you a hint, didn't she, in the title of the motion that she sent for you to read? Didn't she? Yes or no?
Yes.
I read the title of what the motion was.
There wasn't anything in the title that threw you off. Pretty straightforward speaking title, isn't it?
Correct.
So you knew that what she wanted was information from you so that she could then file a motion to dismiss the grand jury indictment, to motion.
When she sent that motion, yes.
Okay. And you knew that the special prosecutor that to whom she was referring in that motion was Mr. Wade, correct? You knew that.
Of course you knew that.
Yes.
Because you read the motion. You said you reviewed it, correct?
Yes.
And we're not going to go over all of the, number one, because we don't have time, and number two, the court wouldn't let me. But, but there are a few things that I do want to ask you about in that response, in that aspect. Now, in that motion that you said you reviewed, on page 6 of that motion, well, on page 5, it starts off with, how do we know this? And there's a question mark.
All right. Yeah, Mr. Gillen, I can appreciate what you're doing. I think that's something you can do at argument. He's said as a whole that he got the motion, and he's had his response as to his opinion of how he handled it. I don't see that, again, this really being necessary to go through it line by line of what.
Well, a little indulgence, Your Honor. I'm not going to go. This isn't going to be a 40-minute death march through the motion. I would like to ask about a few bullet points that capture under this, and then I'll move on. But I would ask the court's indulgence in that respect.
Again, I think we've covered it, and I think that you'll be able to argue that this was in that motion and that he had a chance to review it, and he never objected to anything in there or raised it. So
that's a problem, and always ending up last.
It very much is. And next time asked, I'll reshuffle the order.
Well, we did earlier with Mr. Wade, and then
I hear you.
I was kind enough, and then the court said we had to go.
Don't need to draw straws next time.
I'll go with that.
All right. Anything
Thank
else?
you, Your Honor. That's all I have.
Okay. We had Mr. Kucherov potentially still on Zoom.
Yes, Your Honor. And I have just a few questions.
All right. Could we add a spotlight to Mr. Kucherov? I'll let you know when we're able to proceed.
He's himself a lawyer, which makes it that much worse.
Judge, before he starts, can I take a 5-minute restroom?
Absolutely.
2 hours?
Yeah, we've been going 2 hours. So let's come back at 4 o'clock. I'll also know for the record that we received a notification from Mr. Cromwell on behalf of Ms. Latham, and he said he was waiving her presence. And I don't know if he later decided to join us by Zoom, but I don't think he was electing to log in. So after Mr. Kucherov, just in terms of timing, Mr. Abadi, do you have any expectation of how long your, if any, questioning would last?
I don't imagine my questioning would be very long.
Okay, well, let's get back in at 4 o'clock. Mr. Bradley, you can just step out of the jury room.
Okay. Wait, I'm muting that. Why can't I? Okay, so we are on a 5-minute break. Let me move my audio up. All right, so what y'all think? I'm not gonna stay for a body's redirect or cross. I'm not even sure what they're calling it. It might be cross for him. The state attorney who's been objecting like a crazy person. He's going to have an opportunity to attempt to rehabilitate Mr. Bradley, which could go very badly because he might wind up opening the door to other things, trying to rehabilitate this guy. But we can see. So my take on this whole proceeding is that Bradley's testimony is in contradiction to the testimony offered by Wade and also by Fanny. It also contradicts the testimony offered by Miss Yurdy, but it does corroborate. It corroborates, not contradict. It corroborates the testimony of Miss Yurdy that the relationship, in fact, did start before he was appointed. Bradley is a bad witness. He's a bad witness for everyone, though. He's not just a bad witness for the defense. He's a bad witness for the state, right? He's a bad witness, but what he has already said can't be refuted, right? So he can try to play coy. He can try to discredit himself. He can try to, oh, I just said that because I was speculating. But the truth is, you don't speculate about things unless you have a basis of information, right? You start from somewhere. You have to have a basis of information in order to speculate. And so he had to have known something. So I think that the whole I was speculating is bullshit. You had personal knowledge at that time that relationship started way before he was appointed. Now, let me be clear. Fonnie Willis and Nathan Wade could have all the relationships they want. Prosecutors date prosecutors, prosecutors date cops, cops date defense attorneys. All of that happens. I get that. The problem here in this particular case is that this individual was appointed and received a salary. As a result of receiving that salary, he then conferred benefits on the person who appointed him. That, my friends, is called a kickback. Okay? That is a kickback. So, and it's not permissible. So that's the problem. They are trying to determine when the relationship started, right? And whether or not Fonnie Willis received any financial or personal benefit as a result of it, which is why they're asking so many questions about exactly when it started and when he was appointed in relationship to the relationship, and when all of these trips happened, that she received a benefit as a result of appointing him. Because remember, before he got this job, his financial affidavit in the divorce case was that he had $2,000. He didn't have Aruba money. He didn't have Bahamas money. He didn't even have Tennessee money, right? But as soon as he got that appointment, 2022, come 23, they all over the town, all over the globe trotting, Aruba, Belize, right? Now she says she played for Belize, fine, right? But all of the other trips he paid for with his credit card, with money that he got from his work for the state. If he then turned around and bestowed privileges on her, that is a crime. That is illegal. Much less flouts the rules of ethics for prosecutors. I mean, for all lawyers, I should say, right? So all lawyers are bound by the rules of ethics, and the rules of ethics require that we avoid the appearance of impropriety. You have to avoid even the appearance. So I hear commentators saying, I don't think the judge is going to kick them off because they haven't established any actual impropriety. That's not what the rules require. The rules don't require actual impropriety. It requires the appearance of impropriety, and it requires the appearance of impropriety because, and this is the part that people don't always explain, because impropriety, when people see impropriety like this in a system, they think it's broken. They don't trust the system. They don't want to participate in the system, or they show up and they want to fuck the system, right? They want to show up as jurors so that they could either hold out or they want to find somebody guilty who's not guilty or whatever. They have an alternative agenda. We don't want those people. We don't want to cultivate that in the community, right? So as a result of that, lawyers are held to a different standard, right? So that when lay people look at us, they should see the excellence of the system, so that you will be confident that's what's happening in courts is happening fairly, right? So the same is true for Trump's prosecution. I don't give a fuck who you are. You deserve a fair fucking trial, right? And you deserve for people to have confidence in the prosecution. And that is the problem. You already know that there are a lot of Trump people that are just not well, right? So to have them also look at this case and think, oh, this is further railroading, we don't trust the process. How many of those people you think are going to show up for jury duty? How many are going to show up for jury duty? How many people watching these trials, these hearings, these YouTube commentators are going to show up for jury duty? And when they show up, are they going to say, I saw this trial on YouTube, and no, they're not. They're going to pretend that they don't know anything about the case so that they could get on. I said before this hearing started, pro DJ Hurricane, I said that Fani Willis should step down. Like, is your ego so big that you can't see that stepping down would have avoided all of this? It would have saved face. It would have saved embarrassment. It would have saved Nathan Wade from what likely will be a disciplinary problem for him, because he absolutely has made conflicting sworn statements. Under oath, you have made conflicting statements that cannot be reconciled. They cannot be reconciled. Okay, so he's likely going to have to face the bar, the disciplinary bar. They will initiate a complaint sua sponte, right? On their own. That's what sua sponte means. On your own. They will do it on their own. They have to wait for somebody from the community to lodge a complaint. They could see this shit and go, oh, we need to look into this, right? So complaint against Nathan Wade, complaint against Fani Willis, complaint against Terence Bradley, complaint against all of the lawyers that are coming up in here pretending that they don't have information that they do have, engaging in subterfuge and all manner of deception. We didn't have to have this. We didn't have to have any of this, right? So here's my prediction, because they should have been back. They're not back yet. I'm watching the thread on the side. My prediction is that the judge will disqualify Fani Willis, her entire office, and absolutely Nathan Wade. There is no way he can stay on this case, right? And I think that they probably will change the venue from Fulton County. And then they will have, I think it's like the Georgia Bureau of Prosecutors or whatever, will appoint a new prosecutor, new independent prosecutor, and then they will continue on with the case. That's it. Yes, participation in the system is important for democracy. It's important for all of this shit to work. We need jurors to show up. We cannot have trials if no jurors show up. We cannot. We can't have a trial without juries, right? And so if jurors are so disgruntled or so in disbelief about the integrity of the process, they won't participate, or they won't participate in a meaningful way, right? They won't participate in a meaningful way. And that's what this is about. People keep saying, oh, they need to leave her alone. It's not about that. All right, we back.
Here, and everyone else is here as well. You may proceed.
Mr. Bradley, did you use any documents to prepare for your testimony today?
No, I did not.
Last time you spoke with Gabe Banks?
The day that, I don't have the date, but it was the date of whenever the phone call happened.
And you know his wife, Kyra Banks, works for the DA's office, right?
Kyra, not Tyra, y'all.
Yes, correct.
When was the last time you spoke to Mr. Wade?
I haven't spoken to Mr. Wade personally in a year, 2 years actually, when I left the firm.
Miss Willis?
I never, my interaction with Miss Willis was never where I would pick up the phone and talk to her, or that she would, or anything like that.
Mm-hmm. So you didn't hang out with Miss Willis? You didn't have a personal relationship with her?
No, I never had a personal relationship. I mentioned before that I went to a dinner that was after she was elected. That was at a steakhouse, but it was some 75 to 100 people there.
So you knew of her, you just didn't have a business relationship or a personal relationship with her, or at least a close one?
I knew of her from she was in the DA's office, and I had criminal cases, but I did not personally know her, no.
And not having known her, not really hanging out with her, you've got a contract from her office.
Yeah, how that happened?
Just object as to cumulative asked and answered throughout the.
All right, Mr. Kasherd, I think we covered this ground on the 16th about the contracts. Do you have are you going somewhere else with this?
I am, Judge. If you give me a little latitude, I'll tie it right now.
Okay, you may proceed.
Coming around the mountain, Judge.
You got a contract from the office, not knowing or having a good relationship or a good working business relationship with Miss Willis.
That's correct.
That's because Nathan Wade steered that contract to you.
I don't know how it came about, but it was presented to me at the office about the contract, correct?
Who presented it to you? Mr. Wade?
Yes.
Is that, and he owed you money, you said at one point.
Say that again?
Owed you money at one point?
I don't recall saying that he owes me money.
Did he owe you money at one point?
Not that I recall saying that Mr. Wade owes me or owed me money. I don't recall ever saying that.
I didn't ask whether you ever said that. I said, did he owe you or did he owe you money in the past?
No, he didn't owe me money.
And so he steered this contract to you, to your office, and you weren't really talking to him? You hadn't talked to him for 2 years?
The contract was in 2021. I didn't leave until 2022.
So you didn't talk with him that whole time?
I left in 2022. I haven't really spoke to him since 2022 is what I stated. When I left June of 2022, around June, August dates of 2022.
Other than your, one last question, other than your attorney, who did you speak with today about giving testimony in this case today?
I spoke to my attorneys, Charles Graham and B.C. Chopra.
And I have nothing further, Your Honor.
All right. And again, I'll just double check to make sure. Did Mr. Cromwell ever join us by Zoom? Do we? All right, thank you. So just for the record, Mr. Cromwell has
no question.
Been apparently watching the proceeding. He had waived his client's presence and didn't have any other questions.
Okay.
So turning it over to Mr. Abadi.
And I have no question.
Oh, very nice.
Mr. Bradley, you can step down.
The court reporter's like, okay, very well then.
I'll take this one.
Okay, so what now, Judge? I think he set it down for Friday for arguments.
May I be excused?
That's right.
I have a follow-up based on some questions, and it's just about the text.
And what, just by way of proffer, what about the text?
Just to admit, so when other people asked about the text, some of them weren't in the record today, so I organized them. They're the ones that have been talked about today, so I just organized them. I just wanted for a point of reference to have them.
Okay. And do we need Mr. Bradley for that?
I don't believe so, but
Have you marked them?
yes.
Have you showed them to the state?
I gave a copy to state, but so these
Mr.
are.
Bradley, just hang on just for 1 second, just to make sure.
Well, I give you all of them. So.
Admitting all of them.
I can't see. Oh.
And while he's looking at that, Mr. Bradley handed me Defense Exhibit 23, 24, 25.
Judge, I didn't realize that they were in my folder.
Oh, is that from the hearing? From on Friday? All right, well, thanks for returning those. Let me make sure. Okay, so I've got 23, 24, 25. Anything else in your binder? All right, good. Okay, and have we come to any conclusions on, what, I'm sorry, how did you mark it?
I marked it, I think we're up to 39, surprisingly the state of Texas.
All right, Defense Exhibit 39 is tendered and admitted without objection.
Well, no.
Oh, I'm sorry. Oh, okay.
Text messages that weren't referenced today are confronted
Okay.
As it relates to Mr. Bradley.
So these are additional text messages, Ms. Merchant?
Yeah, so what I did was they objected that they weren't complete because like the first part of the text wasn't there. It was just like, oh, there was something before that was said. So what I did was I spent this whole time trying to line them up so that I had the beginning of the text, the middle, based on their objection. They have all the text. They can admit all of them if they want them complete. And
All right. How about I'll just do this. Just I understand the desire just to have the complete text chain, just for purposes of completing the record.
He is tired.
You know, I think that there's no point in having him sit here and authenticate.
Nobody should be getting gifts.
To admit it as a court's exhibit.
No gift. Oh, Supreme Court justice. Yeah, they don't have. They don't.
Previously tendered or referenced in testimony.
Rules of ethics don't apply to them.
Are relied on for making any findings, but just so it's on the record, we have the complete text chain. Should that ever be an issue for some reason? Any thoughts?
She sure
about that,
did.
Mr. Abadi?
D. She took them down.
I was able to briefly look at Ms. Merchant's phone when she allowed us to have it for a couple of seconds, minutes, and there are text messages I know that I saw that are not in what is purported.
She represented Mondo.
Okay.
She didn't date him.
Ms. Merchant, what about that?
I let them take screenshots of the ones that they thought weren't there, and he sent them to himself on my phone. I have also offered to hook my phone up to whatever it is. My phone's an iPhone. This is an Android. I can't download it like you could in a normal text. I told them if they had a system to get all of my texts, they could have every single one.
We can definitely do that.
That's hilarious.
Yeah, Mr. Rice.
Thank you, Black Showman.
They are specific parts of the conversation. The entire text chain isn't a continuous conversation subject to 601. Those particular parts, given the witness's testimony, should be admitted to source of evidence as prior and consistent statements with this testimony today. It would be up to the government and the state if they then want to introduce the rest of it.
They're not using microphones, so it's terrible.
Sure, I think that's a fair point that if he had been confronted with a particular text, that could have been the opportunity to admit it as a prior and consistent statement for impeachment.
Hello?
And some of them were.
Some of them went in.
But apparently some of them were not.
I'm taking those out. So it's gonna, I'm taking out the ones that they said he wasn't.
Gotta know your rules of evidence, Ashley.
It just makes it more.
You gotta get evidence in evidence.
All right, so we have a newly compiled 39. Let's see what the state thinks of that one.
The state is, are they gonna just agree? They're gonna object. They'll find any reason to
All
object.
right, regardless, if that's now what is being discussed, again, I don't see a need for Mr. Bradley to be here any longer, so I'm going to excuse him at this point. Thank you, Mr. Bradley.
All right, Mr. Bradley.
Of course. Take care. Yes, that's right.
What's Tamala man husband name? Don't he look like the dude from the Tyler Perry show, Mr. Brown? Mr. Brown, you up there lying? Mr. Brown was up there lying today. Lord, Lord, Lord.
The last time I did it was Witness Pro.
If you didn't confront him with it.
Witness Pro. I had to make a witness. Okay,
So where are we with Defense Exhibit 39?
it might be helpful if you looked at them so you know what we're talking about, but I confronted him with all of these. Right, I know. So Exhibit 26, I put in so that it made sense, so you could read it. You know when you're reading a text and it's a conversation?
Sure.
They're upset that they're not in order now, I guess. I don't really understand, but if you want to look at them, you can.
Well, let's start from the beginning. What is the purpose of Defense Exhibit 39?
These are the ones that I showed him, and that I showed him today. So there were a lot of follow-up questions on it, and so I realized, okay, well, they should just be in the record, because other people are referring to my texts, and they might as well just be in the record. And he authenticated all of them.
All right.
So,
And Mr. Rice?
And not just in the record, Judge, they should be admitted as substantive evidence because they come in as prior and consistent statements from Mr. Rice.
Okay. All right. So to that end, Mr. Abadi, is there a particular text message in there you think was not authenticated. I understand you're saying, well, maybe one of them's already been admitted, so, but otherwise, just having a omnibus, here are all the relevant text messages exhibit. Is there an authentication objection? Is there any other kind of objection like that?
Yes, because he didn't authenticate that all of the text messages were
So he was going to object.
from him and between Ms. Merchant or the context of him. So I think that's the problem. When you don't, for example, if the state was to provide, I guess, just a specific text chain from a cell phone extraction, there would be an objection because the state would be making the determination as to what is relevant. Really, all the information should be turned over, and it's for the parties to object and Your Honor to determine which parts of the conversation are relevant or not. I don't have all of the conversation. The conversation starts in September, and then so there's a few text messages from.
So what's the basis of your objection, counselor?
Ms. Merchant has determined that jump in between.
What
is
rule?
not relevant. That's not appropriate. It's for Your Honor to determine what's relevant and not. And I can't make an objection as to what I don't know. I can tell you what I've read. It seems as if there are definitely parts that are missing that would make certain parts of the text message.
So object under the rule of completeness. That's it, period.
That she didn't.
What's
confront
extra
me,
words?
Would be my objection, but only the relevance can only be determined if we have the full chain. So she's determined which ones are relevant. That's your job.
Sure. So
No, that's not just the judge's job.
Didn't she just
You have to
try
make an
do the
offer
full
that your
chain
evidence
as an
is
exhibit
relevant.
Just a moment ago.
No, we don't have the full chain. The full chain is text messages that begin in September and continue down.
Damn.
That's not contained in
It was contained. Why is he texting her? I am tired and I'm hot. You know, you see me take my sweater off.
Mr. Gill.
Yeah, not a problem. And I offered that when we were here before. I just told me didn't have that technology. But let me just go through them one by one. It might be easier. I was trying to just do it quickly all
You
together.
can just hand them to me.
So the first.
Just hand them to me. I can read them. And while I'm reading them, Mr. Gillen, what did you have to add?
Great point, Your Honor. Apparently, Ms. Merchant has allowed the state to take screenshots of what they now contend would be the larger perspective on, and I disagree with them about the rule of completeness, but it's their job when something is admitted that if they have an objection because the context is not appropriate, they then move. And the state should move.
But you still have to give them the full document in discovery.
Change that they had. So the real issue here is their failure to comply with the rule of completeness once they had the material from the last year.
He said they don't have the material.
Well, isn't that what he's doing now? Because now they're being tendered?
I don't think that he is. I mean, it seemed to me that what was happening here is this Ms. Merchant has tried several different ways to get it in. She wanted everything in, and they objected to that. Then she wanted the segments in that had been, the witness had been asked about, and that's what she's trying to do. My point is that if they're, at the time of frankly, of moving under the rule of completeness is at the time of the tendering. If they want to tender something to show that it should be included to be complete, that's on them, not on Ms. Merchant.
The rule of completeness says that it has to be done at the time that the original is offered.
Ms. Merchant's cell phone. I only had time to literally find one part of the text message to then send to myself before Ms. Merchant demanded her phone back. So I did not have the opportunity to screenshot every act or every missing part of the conversation to then do as Mr. Gillum is saying that should be done, but it can't be done if I don't have the information. So,
Well, he is entitled to have the
there are
information.
many of the text message screenshots that you have printed
But
out.
why are you making this argument now?
In front.
Why wouldn't you
Mr.
have
Bradley
said that
refreshed his recollection.
when she was putting it in evidence? Like, hey, this is not
Inadmissible
proper.
evidence. If anyone missed the opportunity, it was the defense counsel to confront him.
All right. I don't think we need to go back and forth any further. Ms.
Good
Merchant,
judge.
you've offered, you said to print out a complete chain of every text exchange with Mr. Bradley since you began corresponding.
And that's how you saw
I'll give you the chance
resolve
to do
that.
And you can follow up by email with that exhibit. It would be the complete chain without any deletions or removals, and we'll have that marked as
Okay.
Defense Exhibit 39.
Judge, I have got to respond though. That in court
There you go.
Friday at 1:57, when Mr. Abadi texted himself the screenshots, I literally wrote him, "Do you want any other screenshots? I have nothing to hide. You can download my phone if you want." So
All right, we're done. Okay, so
She
I'll
like,
wait
nah.
to hear from y'all.
He
on
pump
Tuesday
faking.
9.
That's basically what she's saying.
And
All right.
is there anything else to take up before we discuss Friday? Just kind of throwing it open to the floor.
I wonder if he's gonna rule from the
Seeing
bench.
none, I believe I'd asked and put it out there among defense counsel to be considering how they would like to organize their arguments on Friday. Has there been any decisions reached on that?
Tomorrow to determine that.
Okay.
And I can email the court when we're done with that. But we are going to make it as efficient as possible and break it up.
Break it up in terms of like subject matter or something like that?
Uh-oh.
Yeah.
Their stream is glitching. It's time. It's time.
That's the idea.
All right. What time Friday?
Well, I'll start with, what is it that you're asking for? We'll start there. Just kind of curious.
Well, I don't think we can answer that right now. Number one, the court said, look, if you divide it up, then we can go with that. Or if you can't divide it up, then I'll give each defense counsel a specific period of time. Tomorrow, we'll find out when we meet whether or not we can divide it up in a way that serves the interest of our respective clients. Hopefully we can communicate with the court.
Okay, I'll just wait to hear from you. To the point of, I think the state recently filed their own motion to, I think it formally said to reopen the evidence as to another witness. I only got to read it very briefly, or I don't know if that was just saying in the alternative we'd like to reopen the evidence. I don't know, maybe someone can clarify that, but my thought there and what I think we ought to do Friday and what I would like to do on the issue of the cell phone analysis and this other affidavit filed by the state today is that both parties, any party rather, can make whatever arguments they want based on a proffer, any counter arguments they want to make based on a proffer. They would not be admitted into evidence at this point. And at this point, I need to start hearing the arguments in the law and what we've heard so far. And if I think I'm able to reach a ruling based on that, I will. However, if I think that the proffer is going to make a material determinative point, we can reopen the evidence at that point. But just the bottom line is on Friday, I do. The intention is that we're still sticking with argument, but the parties are free to address some of these issues that have been brought up post-hearing if they'd like to.
Your Honor, excuse me.
Oh,
sorry.
Let me start with Mr. Saban.
I'm alive and well with a quick question.
All right.
That suggests that we do not have to have a witness present on Friday for the cell phone record, correct?
That's right. Friday would just be argument, and counsel can proffer why they think it's significant. And if once I've heard the law and the argument of counsel, I decide that that is going to have some material bearing on the outcome, then we can reopen the evidence and have it properly admitted.
Wow.
Subject to cross-examination.
Okay. I'll explain that in a second.
Okay. Ms. Merchant.
I just wanted to know if the court wanted us to focus our arguments on anything.
What'd she say? Goddamn it! Just no shit.
Well, actually, I think what I'm more likely to do is more along the lines of what I suggested before, is give you all a time block, and you use the time however you think is more effective.
Okay.
What you think is your strongest argument. I don't. A lot has been covered, and there's a lot in the motions that weren't covered during the evidentiary hearing that I would plan to rule on at the same time as well. So I leave that to you. Mr. Gillen?
Your Honor, I know we have other motions to hear on Friday.
Oh, we do?
I thought we did.
I just said disqualification as a whole. So if you have arguments about forensic misconduct, about anything like that, that would be the time for that argument as well.
I consider that
Oh wow.
disqualification.
You want to hear it all?
We had scheduled hearings on the murder.
I sure do,
I
Phil.
talked about that, and then things evolved.
Because I got a lot of
we
fucking
didn't actually
words.
send out a notice
So,
adding any other motions.
if I want to curse, I can curse.
We
Because I'm
have
grown,
some trials
goddammit.
starting next week. The next 2 weeks, we've got some of our homicide trials already scheduled. So I'm going to be following up with y'all to schedule the rest of the pretrial motions that we have.
Okay. So the phone records are not in. You remember that came
That's
out
right, all things
a couple days ago.
disqualification. Anything from the state or any other defense counsel?
Yeah.
All right, thank y'all. All right, we're off the record.
All right. Off the record means we are out of here. Okay. So hang on. Let me get off of this and turn that off. Okay. All right. So real quick, before we get out of here, boogie out of here, we will be back Friday. The court will be back Friday to hear arguments. That means that there is not going to be any testimony. Nobody is going to be called to the stand to give testimony. That the testimony is now closed. As far as the court is concerned, he is not receiving the phone records that were proffered, or I would say that were put in the motion for, I think this was Trump's lawyer, Steve Sadow, submitted a motion for a supplemental exhibit, right? Wanted to have the judge include these records as evidence. And typically when you want to include evidence, you have to have what's called a proponent of evidence. A proponent, that's someone who is going to come in with personal knowledge about that piece of evidence and be able to testify about how it relates to the case, right? Evidence has to be relevant. It has to have some bearing on the case. So he wants to hear a proffer. Basically, he's saying he wants whoever is the proponent of this evidence, the defense, I think is Sadow, to tell him what is the evidentiary value of the phone records and how they fit into this case. What is the value of these cases? Why should I consider them, right? So I don't think that's going to be a hard sell, right? Because they are very detailed. That particular motion has an affidavit from an investigator who has extensive training and experience and education on cell site data tracking and geofencing and all of the shit that they do to try to locate a person via their cell phone, right? So they were able to narrow down Nathan Wade's cell phone on at least as many as 35 different occasions where he was at the Hapeville condo. In contradiction to his testimony, he testified that he had been there less than 10 times. I believe Fani's testimony, he had been there no more than 10 times, right? So when I hear people saying the same shit, I'm like, y'all have homogenized y'all's testimony, right? You've got it to blend and match. That's the homogenize. Because since y'all want to talk about my cursing, I'm gonna give y'all some other words. God damn it. All right, so he's going to have the offer of proof, at which time I think he will then decide whether or not he's going to accept that into evidence so that he can consider that as well. I think he will, because it speaks to the credibility of the witnesses. And one thing that the judge has to determine is whether or not he believes these people, right? Especially when there are contradicting factors, contradicting evidence. So he has to make a test. He has to make a decision as to who's more believable. Is Miss Yurdy more believable when she says that the relationship started sometime in 2019? Is she believable? Or are the text messages, are those more believable than Bradley's actual testimony, right? Because they're I would say they seem to be more reliable. Although I can't for the love of God, right, understand why this guy would be texting with Ashley Merchant unless he really hates Nathan Wade or he hates Fonnie Willis, and he's like, yo, I'm whatever you need, line them up until the shit hits the fan. And she outs him as the one who is giving her information. Then he backpedaled because he starts getting phone calls from the legal community down in Atlanta, like, yo, we heard it's you. We heard it was you. You know, you can't do that, right? You can't talk about this. You shouldn't be able to do it. And then he changed his whole thing, right? So now he clams up, and I don't remember if I said that. I don't recall. And yes, I said that they had been dating, and I did correct you that it was when she was this type of judge, not that type of judge, and that the relationship had been happening. And my response to your question is to the question of whether or not they had been dating before the appointment was an unequivocal, absolutely they were dating before he was appointed. In the beginning of this case, before any testimony began, the judge was very clear. He said, I want to know whether or not this relationship started before he was appointed, and whether or not Miss Willis received any benefit, any personal benefit, personal, financial, or otherwise, as a result of it. He said in the next sentence, because that is disqualifying. That's what he said. He said it because that is disqualifying. So it's not a question of whether or not the actions that have been alleged are disqualifying. The question is whether or not they have been proven, whether they have been established enough that the judge is confident that there is a violation of the rules of ethics. The appearance of impropriety is so much so that it would compromise the integrity of the proceedings if he kept her on. Can you imagine how the Trump case would proceed if Fani Willis's office stayed on and Nathan Wade was the prosecutor? Who's going to focus on a case? Who's going to focus on the actual prosecution? They're not. They're going to focus on the prosecutor. And that's not what you want. You don't want the jury while you're trying to present evidence against this defendant sitting here going, lying motherfucker. You don't want your jurors are going to do that. They're not going to come forward doing voir dire or voir dire, however you want to pronounce it. They're not going to come forward and sit there while they're in the box and go, I actually watched that YouTube, and I don't find you to be a credible person. They're not going to say that and get kicked off the jury. They're not going to say that. They're just going to be like, yes, I can agree. I can be fair. I can be impartial. No, I'm not biased, until they are selected. That's what happens. That's the problem. That's the problem. And trust me, if this is the downside of all of this. If this wasn't all of this distraction happening, then maybe this case would be in a posture where it could be tried before the election. And you heard me. Maybe, if it wasn't for all of the distraction, it could be tried before the election. And you know what? As a defense attorney, the defense lawyers are doing exactly what the fuck they're supposed to do for their clients. They're doing what they're supposed to do. They are causing a distraction. They are delaying the proceedings. Hell yeah. If you was the client, you would want that too. This woman is trying to send you to prison. You want to have that done quickly? Hell no. Hell no. Right? So now you've got the front runner for the Republican Party, who that's what he is at this point now. He just beat Nikki Haley in South Carolina. He is the front runner. Right? Who the hell is calling me? Nope. Somebody tried to scam me today. Somebody tried to scam me. I'm not gonna tell y'all all it, but somebody tried to scam me. An artist, a rapper, wanted to have was supposed to be having a deal somewhere. It was just an aside because I'm fucking pissed off. And they allegedly hit me up. I'm not sure if it was them or them. I don't think it was them. But I couldn't call them. They wouldn't get on the phone. So this is all by text message. And I'm thinking this is a little suspicious. And they're telling me that they have a contract. And I'm like, okay, send the contract so that I can review it. And they're like, okay, we need your banking information. Wait, what? We need you to send us your banking information so we can send you a wire. For what? For the fee. For the fee to do what? To review the contract? Yeah, okay. I need to see the contract first. So you don't send me a fee. I need to see the contract. See, a lot of these scammers get people who are money hungry, right? So you say you want to send me money. I'm going to send you my bank information so you could, motherfucker, I don't value money like that. How about that? I never have. And I never will. It has no intrinsic value to me. So you calling me up saying, yo, send me your bank information so I can send you $2,000, $4,000. Do I look like the type? I'm not. And I quickly was like, yeah, you know what? This don't feel right. And you know what? All you got is your gut. I ain't no fucking Risa Tisa. I'm not out here. No, I'm not going to be doing no 52 part on how I got scammed. Who the fuck scammed me? Get the fuck out of here. I'm not doing that shit. I'm not saying who the rapper was because I don't know if it really was the rapper or some somebody pretending to be the rapper. Yeah, and I literally text that. I was like, yeah, I was born that night, but I was not born last night. So keep it pushing. I'm good. I'm good. I don't need it. Anything that I need, the universe will provide. That's just like, so that shit just had me pissed off on some real shit. Like, yo, first of all, I'm an attorney. I have to do due diligence. I don't let anyone send me any money. Don't send me money ever. Okay? Don't do that. Don't do that. If you send a donation or something, you cash up, that's different. Right? You sending stuff through the internet or through YouTube and, you know, the super chats, that's different. Right? That's different. But if you are trying to engage me on a professional level, don't send me money. Don't send me money. Right? Don't try to ask for my banking information so you could get out of here, man. That shit was crazy. That you know, Sam, that's crazy. That's crazy. You want cash like fun? I don't. This is that's why they will never get me. They will never get me on some bullshit like that. No, I don't. I just don't. And you know what? I gotta say this because for all of the people that are out there fighting on behalf of people that look like us, listen, they're gonna send some agents your way. They're gonna send some people to you. You're not gonna know who those people are. They are gonna present some deals, right, that probably look too good to be true. They probably are. Don't test it. I had a dude, and I knew he was a fucking agent. I knew it. He said he had a personal injury case, right? I should do a recitizo on this one. This one is good. He said he had a personal injury case, and it got settled. And he had a check for like $230,000. I'm not fronting. He had a check for $230,000. He wanted to bring the check to me so that I could deposit it in my attorney escrow account, right? And then once it cleared, he's like, you could, you know, I'm gonna give you like 50,000. And hold up. You would give, why? Why would you give me 50,000? So I'm like, so who's the lawyer that settled the case for you? Because they should be getting a percentage of the settlement. That's typically how that works. And he was like, no, I'm gonna bless you because, you know, you do a lot for our people. He hit me with that. You know, y'all got to watch out with the cultural familiarity. Folks will get you with that every time. And I was like, nah, I'm good. I was like, I'm good. No, I'm good. He's like, you don't want this money? Nah, I'm good. So I blocked him. Do you know this motherfucker got a different phone and called me from a different number? He was like, yo, I've been trying to call you. I was like, yeah, no, I don't want to talk to you. I blocked you. He's like, oh, come on. It ain't like that. Da, 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 da. To this day, I know that motherfucker was sent. To this day, I know he was sent. Okay, so I don't trust. I'm sorry, fam. I don't trust. I just don't trust. I'm dating again. Went out on a date the other day. Fucking disaster. Lying. First of all, if you start off lying, I'm not block. Ladies, we don't have no time for that. I don't have no time for that. You divorced or you not? I'm a lawyer. If you say you divorced, how hard is it you think it's for me to verify that shit? Right? So when I ask that, is your divorce filed? And you hit me with the not yet, that means you're married, bruh. That means you are married. So you know what that means? That means that I don't do married. Block. All right. So Friday. Tried to look and spell it wrong. What you trying to look and spell? Gold crown. Oh God. Let me see if I miss any. No trips, no Aruba trips for Ike. Right. Not on nobody else's dime. Shoot, not on nobody else's dime. But I saw my brother in here. Where he went? Oh, he on the Facebook. Okay, I'm seeing Facebook comments. That's good. What's up, bro? Ham? My biological brother, my real bio brother. I actually got one of those. Yeah, integrity over everything. For real, at the end of the day, I don't ever need money. I don't ever need money. I promise you. You can't take it with you. It does not have any real value, especially in this country, right? Don't ever. What happened to the good-looking dude you were engaged to? Ah, D. We are good. We're friends. It didn't work out, but we are friends. We are friends. He was fine though. Goddamn. we are friends. It did not work out. Unfortunately. But one of the things about being a grown-up is that you understand that everything doesn't always work out, even if you are well-intentioned and you want it to work out, right? And so sometimes you just have to accept. I move on that, right? Gratitude and acceptance. So that's my principles in life. We looked good together. Okay, we looked good, and that's it. No, I can't say that. He's a good dude. We just did it. It just didn't work out. Listen, it's very difficult for me. I will tell you right now that it's difficult to meet men who have been following me, right? Because they then have this idea that they have a familiarity with me that they don't have. And then there's a disconnect between who they think they know and who I actually am. Right? Because you can't know me just because you watch some of my videos. You might get to know the lawyer side of me or how I think and joke, but you're not gonna know me, right? And I might show you some things that you weren't prepared for, right? And I'm the type of chick, I need a dude who's gonna be like, what you just say to me? I need a little pushback, right? Not violence. That's not what I'm saying, but I need to be challenged. I absolutely need to be challenged. And if you can't challenge me, we're probably going to have an issue. I'm probably going to walk away because I'm going to be bored, right? I need to be challenged too. So look, I did look happy. I'm still happy. I'm still happy. Let me say, I'm still happy. I'm still open to the prospect that love is still out there somewhere. And it's we'll see. How do I contact you? Sam Fisher, you can hit me at Ike Speaks. Ike Speaks at gmail.com. Ike Speaks at gmail.com. Ike Speaks at gmail.com. All right, so we will see on Friday what's going on. We'll hear arguments. I'm teaching Friday. I actually teach on Mondays and Wednesdays, and I also teach on Fridays. I teach at one school on Mondays and Wednesdays, and I teach at another school on Fridays. So I'm going to try to catch hopefully it'll be in the morning because I teach from the afternoon till the evening on Fridays. So hopefully I can catch it in the morning, and I'll be able to give you all a little feedback or help you understand what the arguments that are being made. I'm really interested in hearing the proffer on the phone records. I definitely think that's coming in. And again, I'm curious to see if the judge is going to rule from the bench. When I say rule from the bench, I mean, is he going to decide it right there after the arguments? Is he going to say, I've heard all of the arguments and now here's my ruling? I don't think he's going to do that. I think he's going to say, I've heard all the arguments. You will receive my decision, meaning he's going to go back and he's going to mull over the testimony and the exhibits and the evidence, and he's going to issue a written decision. I think this case is far too important for him to rule from the bench, right? I think it's far too important for him to rule from the bench. I think he's going to want a written decision so that he can show his thoughts in the process of how he arrived at his ultimate conclusion. I think that. Yeah, how you gonna scam a lawyer? Lawyers get scammed all the time. I promise. I was listening to something the other day they had on Apple News, and it was talking about it was a reporter. She had been scammed, but someone had called her and told her that, the whole somebody is using your identity and you are a suspect for wire fraud and da-da-da. That one is hilarious. When they call me for that and they're like, oh, well, we're going to send the police there to warrant for your arrest. I'll be like, bring them on. Bring them on, bring them on, bring them on. But she actually was terrified, and they had her withdraw $50,000 from the bank. And then they was like, we need to safeguard it for you. They sent a car to her house, and she went downstairs with the money in a shoebox and gave it to her. Of course, after that, she was trying to call them what's the next steps for this process of me they told her that her bank account was compromised, so she had to take money out so that she could live, right? She needed that funny cash so that she could live while they were still investigating, because she wouldn't be able to do any baking. So she went for that. See that now, that's some white people shit, because black people would have been like, I can't use the bank. Okay. All right, whatever. I don't need the fucking bank. Fuck you, right? But that's not how that worked, right? How people fall for it. Fear. She said she was legit afraid. Like, they were scaring her. Like, these people have purchased property in your name. They was doing all of, they told her all of those things. Like, they're shopping and they opened up this card and that card. She said she checked the credit report. She didn't see any activity, but she still listened to them. And one of the things they do, if they keep you on the phone long enough, is like an interrogation, right? And you crack, just like people who are give false confession, right? And you crack, and she cracked. She cracked, ran to the bank, got that 50 large, put it in a shoebox. I'm like, come on, son. Yeah. So you asking me to send, I don't even understand why. If someone wants to send me money, you got use my phone number. Use my phone number. Why you need my banking information? Why? That's never gonna work. Never. Scammers are bums. I swear, they beat you in the head. Yes, until you give up. They got your wife. Yeah. Oh, they tried to get your wife. They tried to get my mom. They definitely try to get the elderly. Make sure you checking on your elderly family members. They will text them. They will call. They will pretend to be you. They will lie and tell them that the family members are imprisoned or somehow otherwise detained in a foreign country or something like that. My friend just called me and said that there was a warrant out for his arrest for the Mexican IRS. He's a tough brother, but he gave him 5. Oh my God. Yo, that's crazy. Damn. Yes. I'm out. You out of here too? I'm leaving too. I'm out. I'm right behind you. All right. It's time to go. Time to go, family. All right. Friday, we be back. We're going to hear some argument. We're going to hear some proffers. We won't have a decision, but I think we will, we will have a decision soon after that. I don't think the judge is going to, belabor this and draw this out anymore. That's crazy, Nikki. I'm so sorry to hear that. I am so sorry to hear that. I know he is hurt. I know he's hurt. Will you keep this live? Yes, the live will be up, but I think it's under the live tab on here. So it should be on there. It should be both on YouTube and on my Facebook page. All right, fam. All right. Be blessed. All right. It's your girl Ike here. I love you. I really do. Peace. Y'all be good.